Good evening, everyone. It's 6 o'clock, and we're calling the meeting to order. I am Mayor Lawrence Rael, and I'm calling the meeting of Tuesday, December 16th, 2025, a meeting to order. The time is approximately 6 o'clock. This meeting is streamed on the village website. The public can also participate via Zoom. Instructions and overall public participation guidance is listed on the website and on page 5 of the meeting packet. I'll now turn it over to our clerk to continue to read instructions.
Thank you, Mayor. The Village of Los Ranchos is providing the ability for the public to participate in hybrid meetings. As with any application, digital service, or software, the opportunity for failure can occur. Therefore, the village is not responsible for the inability to connect to the meeting either by Zoom, meeting link, or viewing via live stream. The meeting is being recorded and will be available online after the meeting on the village website.
Thank you very much. Would the clerk please call the roll?
Trustee Benavides?
Here.
Trustee Kiefer?
Here.
Trustee Ranovich?
Here.
Trustee Reinell?
Here.
Thank you very much. We have a quorum. If you all would please stand and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all, and happy holidays to everyone listening at home and to those of you who are attending this evening. We now need to move to approval of the agenda. Do I have a motion to approve the agenda?
I'll make a motion to approve the agenda.
Do we have a second?
Second.
Second.
It's been moved in second. Any changes to the agenda? Any discussions regarding the agenda? Seeing none, all those in favor signify by saying aye.
Aye.
All opposed, same sign. Motion carries. Now we'll go to general public comment. Only those participants who signed up prior to the meeting can speak on topics that do not appear on the agenda under public comment and will be given approximately 3 minutes. To be fair to others waiting to speak, a timekeeper will make an announcement when the allotted time is up. Therefore, it is important to keep your comments short and plan on making your points as quickly as possible. No action can occur on these items. If you have questions, please feel free to contact staff during business hours. Danielle, please proceed by calling up the individuals that have signed up for general public comment.
Thank you, Mayor. And before we proceed with general public comment, I just want to make a note that comments on any active planning or zoning applications or applications still within the appeal period are not permitted. These items are or may become quasi-judicial and can only be discussed through the formal hearing process to ensure fairness and due process. The Director of Planning and Zoning may interrupt public comment to advise the speaker if their remarks fall within the quasi-judicial case. With that, we're going to go ahead and get started. Ms. Teresa Rael, if you would please approach the podium, state your name, and you have 3 minutes.
Teresa Rael, 1005 El Alhambra Circle Northwest, Los Ranchos. I'm disappointed that Fred's not here. I want to express my sincere appreciation to Fred Radosevich for his support with the Village Neighborhood to Neighborhood Crime Watch Group. Fred helped organize meetings with what started out as 3 neighborhoods, and now it's 17 neighborhoods or areas in the village, communicating suspicious activity and crime with each other. He arranged for BCSO to be present at meetings to meet the residents, hear the residents' concerns, and answer any questions. He also shared the BCSO calls for service each month. And most importantly, he always took all my calls. Again, I just wanted to thank Fred for his consistent support and dedication to the village's safety, and I will miss him. I would like to thank Gil Benavides and George Radnovich for the past 4 years serving as our village trustees. Alan and I appreciate the good work that you've done. especially through the difficult times that your term covered. Your service and experience will be missed. Again, thank you.
Thank you, Teresa.
Thank you so much. Mr. Nathaniel Roybal, if you would, please state your name and address for the record, and you have 3 minutes.
Mayor Rael, trustees of the board, thank you for giving us time to comment. My name is Nathaniel Roybal, 4650 Los Poblanos. I'm a new face around here, certainly a new neighbor, and really happy to be in Los Ranchos. And I love this hybrid format, and thank you for giving me the opportunity to talk. I think it's going to be a lot of fun. What I've provided is just a handout that I've done and taking some time to walk through our Agri-Center. And the Agri-Center, as you know, is 25 acres of land, and the call on this is an opportunity for us to work a little closer on our stewardship and cleanup of the Agri-Center premises. There's photo documentation here that I've shared with you, and the call to action is that we spend a little more time as trustee and volunteers and members of the community working to restore, beautify, and manage this site. And so I think it's a site that has a lot of opportunity. I've put some things together here. The first picture is just showing there's a lot of unkept areas, fallen signage, and just a lot of materials left that should be recycled. There's multiple old vehicles that I think should be restored or recycled per the will of the board. There's a lot of construction debris just spread out throughout the 25 acres, and I've provided pictorial evidence of that. A lot of tree trimming debris, which has been there likely for decades. Boarded up house that I know has maybe some historical significance, but it looks more like an area of abandonment rather than an area of restoration. And a lot of beehives that are kind of a missed ecological opportunity. It'd be nice if they were functional. They're obviously not if you walk past them. And then the last thing is there's a lot of excessive lighting on that Agri-Center. It's the most bright building in the entire Los Ranchos area, by my opinion, and probably not the most appealing building. And so I'd really encourage you to turn off those lights at night or make them motion activated, which would be a lot better for the wildlife. And so this is not meant to be just a complaint session. I'm here to offer my services, happy to help with the cleanup, happy to organize a volunteer cleanup. It can be done really quickly, but it can become a sense of civic pride for all of us. And I think we can do better, and I'm willing to help do that. So thank you for allowing the comments.
Thank you very much.
Thank you. Mr. Robert Chavez?
Robert Chavez, 324 Enchanted Valley Place, Northwest, Los Ranchos. Mayor, trustees, staff, and members of the community, I want to sincerely thank George Radnovich and Gilbert Benavides for their outstanding leadership and vision, which have left a lasting mark on our village. Their advocacy led to the creation of the Citizens Advisory Committee. This committee was charged with a review of C1, the pilot conservation, and the VC zoning. By inviting residents into the process, you not only strengthen public trust, but also ensure that our village future reflects the voices of those who call it home. Tonight, we continue this work with the VC zone changes. This is the final request for zone review supported by 654 petitioners in March of 2022. All of these efforts have balanced growth, conservation, and the unique character of our village. Such collaboration happens because leaders choose to listen. Beyond the collective achievements, your individual efforts have truly set you apart. Gilbert, your dedication protecting our village water rights and the acquisition of additional ones have been vital, not just for today, but for future generations. Water is our most precious resource, and your stewardship reflects a deep commitment to our community. George, your work on the first phase of 4th Street revitalization has helped shape the vision that honors our history while improving safety, functionality, and quality of life. This project demonstrates care, patience, and long-term perspective on what makes our village thrive. It has been a privilege to work alongside you guys for nearly 4 years, some of which very tumultuous ones. Thank you both for your service, your integrity, your dedication. Our village is stronger because of your efforts, and we truly are grateful.
Thank you.
Thank you, Mr. Chavez. And with that, Mayor, that concludes all those who signed up prior to the meeting for general public comment.
Okay, thank you very much to the speakers. Appreciate you all coming up this evening. Now we'll go to presentations. As you all know, we had an election here just recently, and we have a new school board member for our North Valley area of IPS. And I'd like to introduce Ms. Rebecca Betson, who is our new school board member representing this area. And I asked her if she could come and just introduce herself and say a few words. Ms. Betson.
Thank you. I want to, good evening, and thank you all for Mayor Rael and trustees for welcoming me this evening. I want to introduce myself. My name is Rebecca Betson. I am honored to be your new school board member, and I want to work with you guys to, support our educators and our families and keep our schools open and thriving. I don't live in Los Ranchos, but I'm from Los Ranchos. My family I was raised off of 4th Street and Tyler. I live right on the edge of Los Ranchos, which is right here in Lee Acres. So you guys are my neighbor. And, I believe in the community. I want to see our schools thrive. I want to make sure that we hold APS transparent. And when there's major decisions that need to be made about our schools, I want to make sure our community is involved in those discussions. I don't want it to be sneaky, and I don't want it to be something that we don't know that's happening, and all of a sudden it's in our face. So I want you to know I'm very personable. You can reach out, you can talk to me. I was an educator for 27 years, so I was in the classroom. I know what it's like for our teachers who are in the classroom. I know what it's like to be a parent and a grandparent of our students that are attending public schools. And I just want you to know that I'm here to represent our community. So.
Thank you very much for being here, and thank you for running, and obviously, we'll thank you for serving as well. I'll turn over to see if any of the trustees have any comments, anything they'd like to share with you.
Thank you, Mayor. I was really happy to see that you won, and I'm looking forward to seeing how you do and all the positive things that you're going to bring to the board. So thank you very much, and thank you for your compliments, too.
Oh, thank you.
And yes.
I'll just say welcome. I know you and I talked while you were campaigning, and you came to my house, and we had a great conversation. So congratulations on the win.
Thank you so much. Yeah, I met several of you guys while I was campaigning, and it was a great experience.
So
Trustee Donovan.
I also had the pleasure of being able to talk to you before you were elected, so I'm happy that you were elected. And we did talk about the lack of transparency, and I think people are going to hold you to that. And of course, our schools, in particular, Los Ranchos Elementary is dear to me because that's where my 3 children went to school. I am very concerned about the future and increasing the enrollment to sustainable numbers, right? That's top of my mind.
And I'm with you. I think increasing enrollment is great, but I also think that we should embrace and ask APS to embrace small schools, because I think that we keep asking our students to have better outcomes, and really the research shows that if there's small classrooms and small schools, they do better. So I'm going to work really hard to try to make sure that, you know, our schools are thriving. And I would love to see enrollment go up, but I also want to say if it doesn't go up, that we need to really work hard to try to say we can stay open even if we don't have big numbers.
Right, so there's probably a nice middle ground to be had, right? Because what we saw happen with Taft is enrollment was very poor. The percentage enrollment based upon full enrollment was so poor. That was one of the reasons why big changes were made. And of course, the lack of transparency of how that all came about was a major complaint.
Yeah.
I just wanted to say, we've had an opportunity to talk several times. The need for transparency in APS is obviously very evident. Okay, and unfortunately, we were left out of many of those decisions. And I certainly do trust that you are going to help us to become more involved with APS, to be, to be at the table, so to speak, so that we can ensure that our community and the students that are served in this community are able to be successful. And so I greatly appreciate your effort. And again, congratulations on your election.
Thank you so much.
And Ms. Betson, for my part, I would say the transparency obviously is paramount. I also would like just to see a lot more collaboration with APS. You all have major pieces of property in the village that many times the village could use to help create an opportunity for community and community development, et cetera. And so I'd love to challenge you, if you might, with the powers that be at APS to look at how we can do joint use agreements to use both Taft and Taylor, or Coronado, I guess now in Taylor, simply because they have huge properties that can be available for weekend activities or for other activities that the community can use the property, and obviously respecting the fact that it is a school, but also that there might be some uses for the community. I know they've done that before, but that would be a really important piece as well. And then the last thing I would say is that we'd love to have you come periodically to give us just these bureaucracies, both local governments and APS or public schools can go their own ways very quickly if there's not some, folks paying attention. So you're invited to come whenever you believe it's important, or maybe when we call you. But we appreciate you being here tonight, and we look forward to working with you.
Thank you. Yeah, I would love to come and I would also, I think you guys have an education group that already meets. So I would like to know when they meet, and I'd like to be part of that as well.
We'll get you connected with them.
Okay.
Thank you for being here.
Thank you.
And happy holidays.
Thank you, you too.
All right, we'll move on to item number 7, approval of the minutes. We have 2 sets of minutes. We have the minutes that need to be approved, the minutes for November 16th, 2025, regular meeting. We'll take one individually. Do we have a motion to approve the November 16th minutes?
I'll make a motion to approve the November 16th minutes.
Do we have a second?
Second.
We have a motion and a second. Do we have any changes, any corrections to the minutes?
Oh, I have one change.
Okay, Trustee Brenovich.
On page 13 and 14, only part of what I said is there, and it looks pretty negative, so I wanted to add the rest of what I said. So I'd like to add the sentence, I also said that I thought, obviously this would have to be translated, Danielle, but I thought the village should do more to reach out to residents to talk to help the village overcome those divisions.
Okay.
I have.
Is that all you have?
That's the only
That's the
change
only-
I had.
Trustee Benavides.
Yes, so just an observation, Danielle. I mean, I think I spoke for a while, and I think you gave me 3 sentences. But, which is okay, but I'm going to probably put a little pressure on you for this meeting. So I'm trying to find the actual sentence, but, here, trustee reports. I'm getting to it. You have 2 bullet points, okay? First bullet point's fine. Second bullet point has two sentences. What you said that's incorrect is, you know, it's just the way it was worded. You know, I think I said something about my number one fan is my wife, and things are, I was talking about letting go of certain things and holding on to certain things, and holding on to certain things was the family, the home, and, you know, those sort of things. But that didn't come across, so maybe we'll just fix that. It's a little personal thing, but if you want to, after the meeting, if you want me to give you a sentence, I'll do that.
Okay. Any other corrections or any additions? All right, those will be done. They seem to be minor in nature, so
Yeah.
we'll get those fixed. There's a motion on the table for approval of November 16th, 2025 regular meeting. All those in favor signify by saying aye.
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 Opposed, same sign. All right, motion passes. Now we'll move on to the December 1st, 2025 special meeting. Do we have a motion to approve the minutes of the December one?
I'll make a motion to approve the minutes for the special meeting.
Do we have a second?
I'll second it.
We have a second. Do we have any corrections or changes to those minutes? Seeing none, all those in favor signify by saying aye.
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 All opposed, same sign. Motion carries. All right, now we'll call to new business, moving on to, see if I didn't miss anything here. New business, okay, confirmation of employment pursuant to 3-11-6 NMSA 1978, subject to the approval of a majority of all the members of the governing body, the mayor shall appoint all officers and employees. Today we are appointing Aaron Callahan as the Agricultural Program Director for the Agri-Nature Center and Andrew Thorne, Farm Manager for the Agri-Nature Center. Mr. Avila.
These applicants went through a selection process, including interviews, were recommended to the mayor for hire, and he has made appointment, and now falls to the Board of Trustees to confirm that appointment.
And members of the board, just for your all's information, a little bit of background, Ms. Callahan worked for the village of Los Lunas for many years, and was actually, at some point in her career, was the assistant, if you will, administrator or city manager in Los Lunas. Has a great deal of governmental experience, a planner, et cetera, and I think has already hit the ground running at the Agri-Nature Center. And to Mr. Ribal, who came and talked to us, we'll have you meet with her because she's already noticed some of the same things you've noticed. So I think we'll have a great opportunity to do some really good things there. And then Andrew is come to us as is in the farming business, has a farm in Algodones, and quite frankly, actually participates in a lot of our farmers markets. He and his wife do sell here on a regular basis, but he's got a real biology background, agri-nature sort of background. I think he'll do a great job for us. And these two hires, for you all's information and for the community, are hires because I think we have all said the same thing in one way or other through the course of the last 6 months, that we really want to get good staff at the Agri-Nature Center and help it develop and do some bigger things for our community. And these two individuals, I think, bring a lot of that, if you will, experience and understanding. And and obviously, as we all know, Willie is moving on here at the end of the year. So I told him today that we take 2 people to replace him, and so I think they'll do a really good job for us. So anyway, with that, any other questions?
I had no questions, Mayor, but I know our planners at my office have worked with Erin quite a bit. We've done a lot of work in Los Lunas, and I think she's a good pick. So glad she's here.
Great. Any other questions?
Neither one are here today, right? To
No.
be introduced, okay.
No, they're not.
And I think I met Erin before. I think she was at the Harvest Festival.
She might have been.
And I met her there. And Andrew, I do know him somewhat because I met him at the farmer's market, and I asked him for some advice about farming for a particular lot that I have. So I thought he was very helpful. Yeah.
Great. All right, well, any other questions?
Mayor, one question. I know that one of the challenges that has always been faced at the Agri-Nature Center has been staffing, which was, I think, one of the biggest reasons that Willie, made his decision. Is there any chance in potentially retaining him now that we're staffing up the Agri-Nature Center?
Trustee Kiefer, we are having conversations with him, and he has expressed an interest in potentially continuing to do some work. And so we're going to work on that endeavor as we might need of his services down the road.
Great.
But yeah,
Thank you for that.
sure. All right, with that, we need a motion to, for confirmation of the two individuals.
Sure. Motion to approve the confirmation of employment for Aaron Callahan and Andrew Thran.
Do we have a second?
I'll second it.
It's been a second. Any other discussions? All those in favor signify by saying aye.
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 Opposed, same sign. Thank you very much. The individuals are confirmed. Now we'll move to item B. In accordance with the Village of Los Ranchos 2013 Codified Ordinances, Chapter 9, 9.2.2, Planning and Zoning Commission. Membership, the commission shall consist of 7 members who shall be appointed by the mayor with the advice and consent of the members of the governing body to the extent practicable. The commission should reflect and support the diversity of the village and the unique land uses within the village. The members shall serve a term of 1 year and be reappointed for more years by the mayor with approval of the Board of Trustees. Members shall reside within the village limits. No member shall be appointed to a term that will extend their tenure beyond 5 full years. Planning and zoning commissioners for calendar year 26 January through December. The following individuals have been named, and so, Madam Clerk, would you please name the individuals for the record?
Thank you, Mayor. This is in alphabetical order. Mr. Daniel Bales, Emerson Paul Chivington, Tatiana Duran, Claire Haywood, Mary Homan, Robert Martinez, and Drew. There we go. The ones with the asterisks, Mary, Claire, Robert, and Drew are currently serving on the commission. The others are newly appointed.
Any questions from the trustees?
Mayor, I have just one question. I know Mary has been on planning and zoning for a while, and I know there's a 5-year term limit. Are we close to that, or?
Madam Clerk, I think we're,
I believe she's on year 4.
I think she's on year 4.
So
Or this would be coming up year 5, or completing her term, if I'm not mistaken, but we can verify.
Thank you.
Any other questions? If not, I need a motion to approve the membership of our Planning and Zoning Commission.
I'll make a motion to approve the membership of the Planning and Zoning Commission starting January 2026.
Do we have a second?
I'll second it.
All right, any other questions? All those in favor signify by saying aye.
Aye.
Opposed, same sign. We have a Planning and Zoning Commission. Mr. Attorney, thank you all for serving. All right, now we'll move to Resolution 2025-12-01, a resolution recommending budget adjustment revisions related to the general fund. 101, Road Fund 216, Special Revenue Fund 299, Capital Infrastructure Fund 311, and Farm Camp Fund 505. Ms. Silva to explain the resolution.
Thank you, Mayor. Mayor, trustees, before you is Resolution 2025-12-01. This resolution, you have a handout that was put by your seats today. There was a correction after the packet went out, and I'll go over that, but so there, just make sure you're looking at the correct sheet. However, this resolution is for being in compliance with the budget state statutes and making sure we do not overexpend any funds. We looked at all of the funds for the mid-year cleanup to see where funds were needed, and based on spending and what activity is going on, there were 4 areas where we felt that we needed to do a budget adjustment. The first is for capital improvements for the water rights. We are getting close to where we can actually complete that transaction, so we are looking to increase and add those funds to the budget. The second is to transfer funds from our road fund to our capital projects fund. This is for the match for our co-op funds. We already have completed the repaving and striping for the year. However, our match needs to be moved from the road fund over into the capital improvement fund just to make things clean for the accounting process. The third item here is for the match that we need for our Water Trust Board grant to support the Agri-Nature Center. And the fourth, I'm sorry, there's 5 items. The fourth item is for budgeting for the purchase of needed equipment for facilities department, as well as maintenance and improvements to the Alfredo Garcia barn for adding a bathroom, upgrading electrical system, and general repair. And the last item is to transfer funds from the 505 Farm Camp Fund into the 299 Special Revenue Fund. So this bar is moving the funds out of the 505 fund because this is an obsolete account. We used this account when we hosted the farm camps and we needed money to be able to pay volunteers. Now that we partner with Explora, we no longer need that fund at all. So we would be moving that into the 299 fund for the Ag Department to still support the Agri-Nature Center, but to make it available to be used for the purchase and install of kiosks for the Edible Trails Grant. So I stand for any questions.
Trustees, any questions? Trustee Ranovich.
I have one question, Mayor, trustees, and Tammy. The fourth item, I've said this, I believe, 3 times over the last 4 years or so. We really need to do an environmental study of the underground conditions around that barn, because as you know, that was the Chavez family estate, or I should say the hacienda, back in the day. And we really shouldn't be doing any excavation or tunneling or anything like that. And I brought it up in the ICIP, I believe, as well. But we need to hire an environmental firm to do a study to make sure that we're not touching anything that has some history and that would need to be mitigated in some way if it were found. So I'd like to add that to the appropriation, and if that's more than the 356,000, then so be it. But I think it's really important to do that.
Okay. And Trustee Ranovich, I couldn't agree with you more. If we're going to be doing any kind of that kind of work, we would certainly have to go through that process anyway. Most of the work that is being contemplated, for the most part, is in the building already, is the electrical upgrades inside the building, some maintenance in the building, and the layout of bathroom facilities inside the building.
I get that.
And so as we start moving to the next level, which is the tunneling or the excavation work to connect the bathrooms, we certainly want to make sure that we do the right environmental review to ensure that we protect whatever's beneath the dirt there in that area.
There may be something under the building as well.
Sure.
Mayor, so.
Okay,
Thanks.
Sure.
I do have something.
Trustee Benavides.
So again, on item 4, I assume this is independent of the ICIP request, which is like, I think 2 million, maybe 2.5 million, right? Just,
Trustee Benavides, Mayor, that is correct.
okay, thank you.
Okay, any other questions? All right, seeing no other questions, there's a motion, do we have a motion to approve the resolution?
Motion to approve the resolution.
Do we have a second?
Second.
See no other questions, Madam Clerk, to call the roll.
Thank you. Trustee Benavides?
Yes.
Trustee Kiefer?
Yes.
Trustee Ranovich?
Yes.
Trustee Reinao?
Yes.
Motion passes 4-0.
Thank you very much. We'll move on to item D, approval of award. Request for proposals, RFP 2025-10-SW, solid waste collection and disposal services. Authorizing Mayor Rael to enter into contract with the following firm, Waste Management of New Mexico LLC. Mr. Avila to explain the award.
Mr. Mayor, Board of Trustees, this RFP was issued. We had 2 respondents, and Waste Management of New Mexico was selected from the RFP scoring. And they are then brought forward here for approval of the award of the contract to continue waste management, solid waste disposals in the village.
Trustees, I need a motion to approve, and then if we have any questions, we can proceed from there.
I have a question, Mayor.
Trustee,
This is my last night, so you're going to get questioned on every single
and
thing.
we all brought our sleeping bags, for sure. Go ahead.
I think Trustee Kiefer brought up at the last meeting an idea that recycling and composting might want to figure into the new contract with them. And they expressed, they being Waste Management, expressed a positive comment about that. So as you kind of work with them for a new contract, anything that we can add that has to do with, you know, new advanced technologies like waste to energy or composting or a circular economy, any of those things that would make their service better for us and for the world, that would be excellent. So I just wanted to point that out.
Okay. Any other questions? All right, we need a motion to approve the award.
A motion to approve the approval of the award, item 8D.
Do we have a second?
I'll second it.
Okay, it's been moved in second. Do we have any questions? Seeing no
Mayor.
go ahead, I'm sorry,
Sorry,
trustee.
I do. So, John, can you tell me about their recycling program? Is it changing? Is it getting any more robust?
As far as the recycling, I know one question came up was whether or not they take glass at the curbside, and they do. So that they have that.
Will that be a service they're offering to us then?
So they take that as part of the recycling and would be part of the service.
Wow.
Oh, okay. That's a step. Any small electronics?
That's not part of the recycling process. And again, I have to be very careful about what was in their, their proposal. I have to be very cognizant of that for at least a while after the actual contract's awarded. And I'm sorry, I just can't recall as far as electronics at this point.
Okay. And I guess my final question would be, was price discussed on not, on what it's gonna cost the villagers if there's gonna be an increase or?
Mr. Mayor, Board of Trustees, cost of service, cost proposal was a good portion of this RFP. And they have come out as the better scored applicant, and just without saying too much.
Okay, great, thank you.
Go ahead, trustee Benavides.
Just out of my own curiosity, who was the other respondent? Are you at liberty to say?
City of Albuquerque.
Oh, interesting, okay.
Interesting. So the city of, excuse me.
Go ahead, trustee.
That deserves. So the city of Albuquerque can put together proposals for RFPs for entities like us. Wow.
Even under, just for purposes of discussion, trustee Ranovich, without getting too much into detail, look, any municipal government can actually enter into a direct contract with another government without even having to go through an RFP process. They had talked to us and had approached us, and I felt it was incumbent upon us that we just put it out for RFP and let whomever bid on it and give their best proposals. The committee that was put together reviewed them and made the decision, so that's sort of how this sort of works itself out. This is, I will say to all of you, this is very unusual for me as well, as sitting in this position, because the state procurement process is a bit different than what I'm used to. But to the extent that we can, there is a protest period that we have to comply with as it relates to these contracts. And so the degree of caution on behalf of the administrator's part is just ensuring that we don't find ourselves in any kind of an issue moving forward. So, so with that, if there are any other questions related to the award, all those in favor of the motion to award the contract signify by saying aye.
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 All opposed, same sign. Motion carries. All right, now we're going to public hearings, ordinance 305, approval to adopt an ordinance pursuant to chapter 11.1.7 of the codified ordinances pertaining to the compensation, of the judge of the municipal court. Attorney Chappell, please swear in individuals who will be speaking on ordinance 305, if there are any.
Mayor and Attorney, I do not have any individuals signed up for this item of business.
Okay, great. Then we'll please proceed with the presentation. If there's anyone that signed up to speak, so this particular, if you will, ordinance, as we spoke about this on the special meeting of the 1st, is to adjust the compensation. As we know, we had an election, and in order to move forward with approval of compensation adjustment, it has to happen prior to the judge taking her or moving on to her next term. And so, John, can you please just go over what the adjustment is on the judge's compensation? Do you recall, Madam Clerk?
Mayor and trustees, yes. The compensation is being increased to $200 per session. It was currently at $50. A session means it could be anywhere from 1 case to 10 cases, depending on what is on the docket. But this hadn't been changed, as we recall, from the 80s. So it's an opportune time to do this, and in order for future individuals within the village to even consider running for this position, we need to make it at a level that's going to be worth someone vying.
Mr. Chappell, do you have any thoughts, comments?
Mayor, I just was going to say that I was asked to draft this. What we did was we took the increase that was suggested by the village. We included the court costs and the expenses that were in the previous ordinance, and we clarified a little bit as to what was meant by a court session to assure that it included an appearance and not case by case, but anytime there was a proceeding in the court. So we clarified that. Otherwise, it's the same except for the amount of the compensation.
Okay. Any questions from the trustees? Yes. Trustee Benavides.
I certainly don't have a problem with $200 per session, but I'm looking at the whereases document, right? And it's unclear if that's really what we're doing here. So I'll read the whereas. It says the village has determined that a reasonable compensation would be $200 per court session. But then I go to the therefores. It says the compensation for the municipal judge shall be set to $150 for each court session. So I just want to clarify that, which would.
Mayor and trustees, that was an error in the ordinance, and I apologize. I did catch that now. It isn't 200, it is $150.
So it's 150. Okay.
Yes, and I'll make that correction on the ordinance prior to signatures.
Okay.
So just for the record, so we're going from 50 to 150. Is that correct? So we stand as corrected. All right, any other, thank you very much, Trustee Benavides. Any other questions from the trustees?
Do we need to amend our,
We don't,
We don't, okay.
we don't have a motion on the table yet to approve. So we need a motion to approve.
Okay, yeah, motion to approve item 9A, ordinance number 305.
Do we have a second?
I'll second it.
Okay. Mr. Chappell, do we need to adjust any of the other piece of the ordinance?
Mayor and trustees, I don't think so. That was an issue that came up earlier, and I didn't read the package, but we thought that had been corrected in both places. We had a discussion about it, but it should be the 150 across the board. And I believe that should be included in the motion because of that inconsistency that the compensation be set at $150 per session.
Do you want me to make the motion? Would that be advisable? Is that what you're saying?
Perhaps amend the motion to include the, making those consistent.
Okay, and I did the original motion, so I can go ahead and amend it. Is that
You
correct?
can do it again as long as the person who seconded it concurs.
Okay. So I would like to amend the motion to clarify that the compensation is $150 per court session. And then go ahead with the approval with that amendment for ordinance 305.
Okay, it's been moved and amended. Is our second concur with the amendment?
I do.
Okay. Do we have any other questions on this issue? See no other questions? All those in favor of the motion as amended signify by saying aye.
Mayor, this one's going to be a roll call
Oh, I'm
vote.
sorry. Roll call, I apologize. We'll go to the roll call.
Trustee Benavides.
Yes.
Trustee Kiefer.
Yes.
Trustee Radnovich.
Yes.
Trustee Rhino.
Yes.
4-0. Ordinance has been adopted.
Okay, thank you very much. This is going to take a little bit of time as we move into the next order of business, so I need to take a swig of water.
Wet your whistle.
You want
All right.
something stronger, Mayor?
We'll wait for the end of the evening for that, for sure. All right, item B, CU-25-03, appeal. An appeal by Clayton Bigby, Nancy, and I don't know, Nancy, if I don't want to mispronounce your last name if you're in the audience. I'm sorry? McGough and Neil Kiefer of the Planning and Zoning Commission's approval of a request for conditional use approval to allow a guest house for the property located at 720 Mullen Road Northwest. The following will apply to the public hearing on this appeal. I would like to ask each member of the governing body for full disclosure or of real or potential conflict of interests or ex parte communication with this item of business. Trustee Benavides?
I have none.
Trustee Kiefer?
Mayor, I do not have an actual conflict of interest, as I have no financial interest in the outcome of this decision. However, because the property is adjacent to my home, I will be recusing myself in the interest of transparency. I'm disappointed not to participate, as this decision could impact the fabric of our community.
Thank you, Trustee Kiefer. With that, new rules of procedure, I think the clerk and you have spoken, and so we'll move on to Trustee Radnovich.
I have no conflict of interest, Mayor.
Trustee Rena.
I have none.
Thank you very much. Both the village ordinance and the village resolutions apply here. Section 9.2.25H of the ordinance guides the process that ordinances referred to in this resolution titled Rules for Appeals, along with resolutions number 2012-1-3, Fees for Zoning. Pursuant to the rules for appeal, I may limit oral presentations. Based on this guidance, we will be adhering to the following time limits, which will apply to the interested parties as follows. Appellants, case presentation will be 15 minutes. This is a total of time to present the case. Testimony is limited to only those that participated in the planning and zoning public hearings. After appellant testimony, questions by the trustees will be permitted during that portion of the review. Applicants' case presentation will be 15 minutes as well. for this case as well, followed by trustee questions to the applicant. There are no time limits for the trustees on either for the appellants or the applicants. Both appellants and applicants will be provided 5 minutes for final remarks and rebuttals if needed. In accordance with the rules for appeals, all appeals of the Board of Trustees shall be deemed quasi-judicial proceedings, which means certain judicial processes and protections are required. All testimony must be given under oath and shall be limited to matters relevant to the appeal. All testimony and questions shall be asked through the chair. The chair will acknowledge those who want to give testimony or ask questions, as well as enter into the record communications received from the public concerning the pending application. All persons participating in the meeting of the Board of Trustees are expected to conduct themselves in a courteous manner. The Board of Trustees shall render its written decision within 15 days of this hearing. The written decision shall include an order and the factual and legal basis for the order. Mr. Chappell, would you please swear in all the participants?
Would everyone that is going to speak on this particular item, not everything on the agenda, please stand and raise your right hand. Do you solemnly swear to tell the whole truth and nothing but the truth under penalty of perjury?
Planning and Zoning Director Shana Schultz will present the appeal. We will commence with the appellants, and you will present the appeal, and then we'll move to the next, or shall I read the whole thing, Madam Clerk?
Madam Clerk, may I approach the podium, please? I have some procedural concerns that I want to address before we get started.
Shannon needs to do the report first, right?
Before we get started, let us make sure we're on the same page here. So we are, is your question related to the process I just outlined, or?
I'm the applicant for C-2503. There are some procedural issues that I would like to enter into the record before we get started. It's very relevant, respectfully.
Mr. Chappell?
Yeah, Mayor and members of the Board of Trustees, those should be done in the order of the presentations of the parties and not separately. And there are a few additional things that I think in a quasi-judicial proceeding that the planning director has asked me to address just to make it clear on how these proceed. The first thing is that in this hearing, the record that you review is that record that was created by and before the Planning and Zoning Commission. That is the record on the appeal. And only things that were presented at that time, and only those persons who spoke at that time can speak at this hearing unless you have a motion by the Board of Trustees to permit additional evidence or additional witnesses. But under, I'll get back under section 9.2.2E, 9, that is the record on the appeal. So that's all that can be presented unless you permit additional testimony. In this particular request, I think that would be additional testimony, so it must come up in that context and the board approve it on a special basis. Also, the procedures on appeal and for witnesses is that the opponents, those people who participated in the Planning and Zoning Commission hearings, can cross-examine the witnesses if they have issues that they want to cross-examine on as part of a quasi-judicial hearing. The rules of procedure adopted by the village say that if there are cross-examination questions, then those should be presented in writing to the clerk or the mayor, and the mayor can ask those questions. They can be modified to make them civil or relevant, but they should come to the mayor, and then you can ask the witness the questions. So they should be presented in writing.
So in this case, sir, we will, if you are interested in making comments, it'll have to happen. Are you here on behalf of the appellant or on behalf of the applicant?
Yeah.
You are the applicant? Then we will let us begin with having the planning director make her presentation, and then we will then have to take a vote as to whether or not we can grant his
Yes,
information.
the applicant had a witness, both a consultant and a witness in the planning and zoning. I don't believe this gentleman actually testified at planning and zoning, did you?
Were you involved in the planning and zoning hearings?
Did you testify at the hearing? Okay. His wife testified, so if he testifies, that will take a motion to approve that testimony.
Okay, if you'll give us a minute, let our planning zoning director make the presentation, and then we will take on the matter that you are requesting. Thank you. All right, Ms. Schultz?
Thank you, Mayor Rael. This is an appeal of a decision of the Planning and Zoning Commission to approve a conditional use for the subject property. As a reminder, an appeal hearing is not a rehearing of an application from scratch. It is a review of whether the Planning and Zoning Commission made a decision that was reasonable, supported by the record, and consistent with the code as written, based on the information that was before it at the time of the hearing. The Commission's role, and my role as staff, is to determine if an application meets the standards of the zoning code, and whether conditions can be imposed on that application and that decision to ensure compliance and protect the public interest. This is the framework within which I made my recommendation, and I believe the Planning and Zoning Commission made its decision. A significant portion of tonight's appeal includes arguments, characterizations, and interpretations that were not a part of the original Planning and Zoning Commission hearing from my review. Some of these arguments rely on secondhand statements, assumptions about intent, or concern about future behavior. As staff, I cannot and I did not base my recommendation to the Planning and Zoning Commission in October on information that was not entered into the record as a part of that hearing. Likewise, the same information that was not present at the Planning and Zoning Commission hearing level could not reasonably be used to argue that the Commission erred in its decision. Turning to the substance of the appeal, the primary issue of concern relates to a garage and how that relates to a guest house. The code, this is going to be section 9.2.7 C5B, states verbatim, guest houses may not have a garage, period. The appellant's interpretation is that this language means a guest house may not be attached to a garage in any way. The code, however, does not use this language. It does not use the word attached. It does not prohibit shared walls. It does not require physical separation. When code language is ambiguous, and I would argue that this language is a little ambiguous, staff is required to apply it reasonably and consistently rather than inserting in restrictions that are not explicitly stated in text. In this case, the reasonable interpretation that I made is that a guest house cannot include the functionality of a garage space, but it can be located adjacent to an accessory structure, connected to an accessory structure. What I was looking for was direct access to the garage. In making my recommendation, I reviewed prior approvals where guest houses were allowed in proximity to or even within structures that also contained a garage. You'll find in my staff report from that evening that I mentioned that there's a precedent for the village to approve guest houses of this nature. Provided that the guest house did not have direct access to the garage, it appeared that that was in line with previous decisions of the village. Because of the concerns raised about the garage, which I did receive prior to the hearing and I heard at the hearing, particularly around enforcement and future use of this space, there was concern from both the commission and the testifiers that perhaps the applicant would knock down this wall between the garage and the guest house to create a guest house that was larger than what the code would allow. I wrote in very specific findings and conditions into the staff report that the commission adopted in full. Those conditions state clearly that the guest house may not have direct access to the garage is for use by the primary residents only, and that the guest house may not be rented out without additional approvals as required by the code. These conditions are very intentional. They are enforceable, inspection-based safeguards designed specifically to ensure that the guest house does not function as having a garage either now or in the future. In other words, the very concern, I think, that is at the heart of this appeal is addressed by those conditions that the Planning and Zoning Commission adopted. Ultimately, the question before you tonight is not whether the code could have been written more clearly. It could have, spoiler alert, I could tell you that. The question is whether the Planning and Zoning Commission erred in their decision, and that their decision was not reasonable based on the information presented to them at their hearing in October. Based on that record from the hearing in October, the interpretation implied, and the conditions imposed, my professional opinion remains that the Commission's decision did meet the standard of review. If the board believes that the guest house ordinance should be revised or clarified going forward, that is a legislative discussion that has merit, but applying a new or stricter interpretation retroactively to this case would be a change in practice, not a correction of error. With that, I'll stand for any questions.
With that, let's proceed with the appellants, and then you'll have that information, and then we'll have trustee questions. Is that?
Yep.
You all okay with that? All right, let's now have Clayton Bigby and Nancy, again, McGough, and Neil Kiefer, please approach the podium, state your names and address for the record, and you have 15 minutes to start your review. Before we, I'm sorry? No, you can decide who wants to go first and follow each other. But before we get to that point, just let me clarify the record. Trustees, the gentleman that wanted to speak earlier related to that is part of the applicant, is that correct? So we'll wait when the applicant portion comes up, and we'll have you, then we'll have the conversation here at the board about permitting you to address the issue. Okay? All right, so appellants? Applicant?
Mayor, point of order. I don't believe a review of the record would show that Mr. McBeebe participated at the Planning and Zoning Commission. I think the lady did, but I don't believe he did, so I think it takes approval of the trustees by motion to allow him to testify at this hearing. Being an appellant doesn't make you a participant at the Planning and Zoning Commission meeting.
So, I'm sorry, I got what you just said. Who is the individual you're referring to?
Of the appellants, only Ms. McGough, I'm sorry. I believe she participated at the Planning and Zoning Commission she is the only one that participated in opposition to this and testified. So other people that would testify would have to be approved specifically by the board.
Attorney, Mayor and Attorney Chappell, by participants, I believe we had clarified the other two gentlemen had submitted written comments to the Planning and Zoning Commission hearing, and that was considered a participant in that meeting. Although they didn't give verbal testimony, you may want to decide how you want to proceed, but that was what was communicated to the other gentleman.
Mayor Rael, yes, all three of these folks did submit written testimony that did get into the record and the packet that was provided to Planning and Zoning. There was only one speaker, but there was written participation, and I'm not sure, Mr. Chappell, where how participation is defined here, if it has to be verbal testimony or if written testimony passes the sniff test.
If that is part, Mayor, part of the Planning and Zoning Commission record and is not new testimony today, I think they would be considered a participant. I reviewed it and didn't find those things. So I withdraw that objection for those people who did submit information to Planning and Zoning before the hearing.
Okay. All right, now we got clarification. Let's move on then. Nancy, Clayton, and Neil, you all decide how you want to come up. You have 15 minutes collectively, and so please make your points succinctly. Thank you very much.
Do I have to state my name and address?
Yes.
Neil Kiefer, 722 Mullen Road, Northwest. I will try and keep this succinct, but I do apologize. I am one that tends to, elaborate quite a bit. Thank you, Mayor, trustees, members of the board. I thank you for the opportunity to speak this evening, and thank you for the time to have devoted to reviewing this appeal. My name is Neil Kiefer, and I'm here representing myself, Clayton, and Nancy, all adjoining property owners to subject property 720 Mullen Road. We appreciate the seriousness with which the board approaches appeals under the Village Code and Resolution 2007-4-2. I want to begin by clearly stating that this appeal is not, this appeal is not opposing guest houses. It is not opposing multi-generational living. It is not about preventing reasonable property improvements. Those of us raising concerns tonight, including neighbors who have previously complied with the same ordinance, support guest houses when they are approved in compliance with the code. This appeal is about consistency, precedent, and the correction application of village law. Before turning to the facts, it is important to note your role under Resolution 2007-4-2, the village's rules of appeals. And I know it's been mentioned by the chair, but under this resolution, the board sits in a quasi-judicial capacity. Your task tonight is not to rehear the application, not to weigh policy preferences, and not to decide whether personal favor or oppose the project. Your task is to determine whether the Planning and Zoning Commission correctly applied the zoning ordinance, relied on accurate and substantial evidence in the record, issued a decision that was not arbitrary, capricious, or contrary to law. When the ordinance has been misapplied, Resolution 2007-4-2 gives this board both the authority and responsibility to reverse or modify the decision. That framework matters here. The property of 720 Mullen Road is a 0.576 acre A1 zone lot created through a 1986 cluster housing approval. Over the past year, the applicant sought a floor ratio variance and a conditional use permit to allow a guest house. On October 14th of this year, Planning and Zoning approved the conditional use with findings stating that the guest house would not have a garage of its own, but would be built within or attached to an existing garage, with no interior access between the two. That interpretation, approving a guest house structurally attached to a garage, is the sole issue before you tonight. This appeal is not about whether guest houses are allowed. It is about whether the attached garage configuration complies with the ordinance. Village Code 927C5B states plainly and without qualification, guest houses may not have a garage. A1 zone ordinance. It does not say unless there is no door, unless the garage belongs to the main house, unless it is attached by functionally separated. None of these phrases appear anywhere in the ordinance. None of them appear in definition section. None of them appear in the conditional use criteria. Those distinctions were introduced through interpretation, not legislation. By approving a guest house that is attached by a wall to a garage, the Planning and Zoning Commission did not merely interpret the ordinance, it effectively rewrote it. Under Resolution 2007-4-2, that is a legal error squarely within the board's authority to correct. The ordinance regulates structures, not doors. It regulates form and mass, not intent. A guest house that shares a structural wall with a garage is by definition and by physical reality a guest house with a garage. If no garage can mean attached garage without a door, then the ordinance has no limiting effect at all. And every future applicant will understandably rely on this approval as precedent. Some have suggested that because there is no interior access, the ordinance is satisfied. But the ordinance does not regulate doors, it regulates structures. I repeat that. A guest house attached to a garage is still a guest house with a garage, by definition and by massing. Structurally, it creates a single integrated building envelope. If no garage can now mean attached garage without a door, then the ordinance is losing its meaning. This is not a new ordinance and is not a gray area historically. The record shows that at least since 2020, village staff and planning directors have applied the provision consistently. Homeowners exactly denied guest houses with attached garages, required to redesign plans, required to build fully detached garages if they want garage space. Written planning director guidance into the record explains the purpose of the no garage. the rule to prevent guest houses from expanding beyond 1,000 square foot limit through later conversion of garage space. In 2024, a house in Alhambra Circle was approved without a garage, citing the same ordinance. Other homeowners, including those I represent, were told the same thing and complied. The history was not presented to planning and zoning with this application was approved. During deliberations, even planning and zoning commissioners acknowledged concerns that garage or workshop spaces could be converted in the future. Enforcement years later would be difficult. The issue was not intent, but capability and precedent. An attached garage or garage workspace creates exactly the risk the ordinance was designed to prevent, a structure that could easily become additional living space, effectively under the 1,000 square foot cap and altering the neighborhood density over time. This appeal does not, this is not about accusing anyone of bad intent. It is about recognizing what the structure allows, not just what is promised today. Under 92.25D2A, planning and zoning may approve a conditional use only if it is not injurious to adjacent property owners or the neighborhood. All adjoining neighborhoods oppose this configurations. Their concerns were grounded, increased bulk massing on a sub-acre 1 lot, loss of confidence in consistent enforcement, and the precedent this decision sets for village moving forward. Several neighbors have expressed deep frustration and discouragement, even feeling that an appeal is a lost cause. This sentiment matters because inconsistent application of the code erodes trust in the process itself. The 2035 master plan emphasizes preservation of rural character, low-density development, and consistent enforcement of zoning standards. Incremental reinterpretations approved one case at a time are exactly how those goals are undermined over time. Under Resolution 2007-4-2, we respectfully ask the board to reverse or modify the planning and zoning decision and require that any approved guest house be fully detached from any garage or garage workspace. This does not deny a guest house. It simply requires that the plans be changed so that there is no attached garage workspace that could violate or later undermine the 1,000 square foot limit. That is the same standard applied to others. That is the standard residents relied upon, and that is standard written into ordinance closing. Under Resolution 2007-4-2, the board's role is not to reconsider policy, but to determine whether the Planning and Zoning Commission correctly applied the ordinance and relied on substantial evidence in the record. And we respectfully submit that it did not. On behalf of myself, Clayton, and Nancy, I respectfully ask you to uphold the code, the master plan, and the principle that the same rules apply to everyone. Thank you for your time, your service, and your careful consideration.
Thank you very well, Mr. Kiefer. Now we will go to Ms. Schultz. Any comments on the presentation?
Mayor Rael, I don't have any comments on the appellant's presentation. He did cite, I suppose I do have one comment. He cited testimony about precedent that neighbors received some kind of communication from a previous planning director. I just want to note for the record that none of that was in the Planning and Zoning Commission record. That was not provided prior to the hearing or at the hearing. So I'm not sure that the Board of Trustees can accept that testimony without voting to accept that, but that's the only comment I have about the appellant's presentation.
Okay.
Mr. Chair, point of response to that.
No, Mr. Kiefer, we will have time for you to respond in the closing. Yeah, so if you don't mind, so we can stick to the rules.
Thank you.
I appreciate you very much. All right, trustees, any questions that you all might have at this point?
Questions to
Either the appellants or to our planning director.
or the attorney, correct?
Or the attorney.
Okay, yes, I do, but can I go first?
Yes, sir.
Okay. I don't know if, this is not the questions I was wanting to ask just yet, but if we want to vote for additional evidence, do we do that later? Do we do that now? And I guess that opens it up to anyone that did not participate in the P&Z.
Mr. Chappell, how should we handle if we want to have additional information for the record?
Mayor and trustees, I think if someone requests it, they should provide identification, what they want to present, the subject of what they want to present, and then you make a decision on a case-by-case basis
Oh,
after you
case by
determine
case.
relevance.
All right, I'm not ready to do that, but I just want to get some clarification.
Okay.
So questions. So nine, and I'm not sure whether to direct it to Shauna or Bill Chappell. And I just want to say that I actually called them about this issue. So some of the questions I'm going to ask them, I asked them before, but I may ask in a little bit different way. And so hopefully they're prepared to answer these questions. So 9.2.25C states that a guest house must not have a garage. Should it be interpreted to mean not attached to a garage? The ordinance did not specific, okay, let me start with that question first, and there's a follow-on to that.
Mayor Rael, Trustee Benavides, the word attached does not appear in the code, and so I would not read in language that does not appear in the code.
Okay. I mean, the ordinance does not specifically prohibit an internal point of entry between the guest house and the garage. Can you explain why this is a problem, even though that particular point is not prohibited?
Mayor Rael, Trustee Benavides, are you asking about kind of the legislative intent behind why the code says that a garage cannot be attached to a guest house?
No, I moved on from that one, I'm sorry. So now I'm talking about the shared wall. The code does not explicitly say there cannot be a door in between, but yet you went ahead and put that down as a condition. Are you saying that's really a gray area and you're basically trying to lock something in that there's nothing nefarious that goes on?
Mayor Rael, Trustee Benavides, yes. The condition that I wrote related to never installing a door between the garage and the guest house was an attempt to honor what the code was saying, to ensure that there would never be direct access from a garage to the guest house.
So why is it a problem for a guest house to have a garage, that being the problem, but it's not a problem for a carport?
Mayor Rael, Trustee Benavides, I'll have to speculate about legislative intent here. When this was added to the code, there was obviously a reason for it. I was not here at the time, but I have heard conversations about this particular requirement and the fear that if a guest house is attached to a garage, which is, a fully enclosed structure, guest houses in the village have a square foot limitation of 1,000 square feet. And so there's a fear that that would be a very easy way for someone to, build a 1,000 square foot guest house, attach it to a 400 square foot garage, get that approval, and then knock down the wall in between them and have a 1,400 square foot guest house.
So I can see why that would lead to confusion now with a guest house bordering a garage, sharing a wall, right? Because that same concern could happen, right?
Mayor Rael, Trustee Benavides, yes, I do think that same concern would happen or could happen. I don't know that that is a valid concern when the village always has the authority to inspect a property to ensure compliance with the code. If we denied every application because of what someone might do with their property, the village would never approve anything.
All right, which leads me to the next question. Let's say the main house has both a house and the main house has an attached garage. Can we then attach a guest house to that main house? And is there limitations as to where that can be placed?
Mayor Rael, Trustee Benavides, the code, I would say, is not clear in that instance, just like it's ambiguous in this instance. If it's the will of the Board of Trustees, I can go over the two examples that I reviewed in making my interpretation. That would be new information for the record, and so that would have to be accepted at some point, but it may help the conversation. There is an example maybe a little similar to what you just described that I used.
Let me ask the same question to Attorney Chappell.
Mayor and Trustee Benavides. I was here when there was significant discussion about guest houses and garages, even though that ordinance was not changed at that point. Primary concern was that it would create a rental unit, and there was a strong desire not to create rental units in separate properties. But the code itself is hard to interpret that you couldn't have a detached garage, and for the very reason that you mentioned. A guest house can be a separate building, or it can be a part of the main residence. And so under that definition, if the main residence has a has an attached garage, the guest house consequently would have an attached garage also. And so, and simply where you can put a guest house creates an issue with taking that position. They can't be attached, because you could build it in the house and it would be attached. My position has been that it says you can't have a guest house, and that the determination to be made by P&Z and the board is whether or not it in fact has a guest house. If you have a residence that has two-car garage, they build a guest house, it still has a two-car garage. Is that a garage for the guest house? Is that a garage for the main, main house? And I think that is a discretionary decision that has to be made by the Planning and Zoning Commission and the Board of Trustees.
It's very difficult. Oh, go ahead.
Trustee Benavides, can I weigh in on this? I think I had the same issue. Because if you take a look at 9.2.3, the definition section, a guest house is one that is a detached dwelling with complete independent living and living facility, okay? Does not mention anything about being attached to another building. It's defined very clearly as a detached dwelling.
Mayor Rael, Trustee Rhino, the definition that I see of guest house in the zoning code says guest house means a second dwelling unit, either in or added to an existing single-family detached dwelling, or in a separate accessory structure on the same lot as the main dwelling for use as a complete independent living facility with provision within the guest house for cooking, eating, sanitation, and sleeping. Such a dwelling is an accessory use to the main dwelling. So I would argue that the code today contemplates that a second dwelling can either be inside an existing structure, detached from an existing structure, but the distinguishing features are that they have cooking, eating, sanitation, and sleeping facilities distinct from the primary residence.
So can you read the reference that Trustee Rennell just stated, saying that the guest house must be detached? Do you not find it?
Trustee Rhino, can you tell me that citation one more time?
Yeah, it's 9.2.3, and I believe it was down that list, but it gave a definition for guest house, and it said clearly in the definition that it's a detached dwelling.
Mayor Rael, Trustee Rhino, Trustee Benavides, the definition that both Mr. Chappell and I are seeing in the code is not that definition. It's the one that I read in to the record.
Oh, wow. Okay. How do you explain that? All right, let me continue. You should follow up with that, but I'll leave it up to you to follow up with that. Let me continue with my questions. Yeah, so, I mean, you can, if you have to put yourself in the mind of the intent of whoever created this, which is a difficult thing to do because you can go wrong in so many ways. But, let's say there was a suspicion that if there was a garage there that something nefarious could happen and they could expand their square footage or heated square footage without anybody knowing. That same suspicion happens to any garage that is attached to the main house, right?
Mayor Rael, Trustee Benavides, yes.
Okay. Okay, now I'm going to get into something a little more complicated. And I'm asking questions that looks like I'm favoring both one way or another, but I'm just trying to get clarification, so I'm not trying to waffle on this issue.
And Trustee Benavides, may I just interrupt for a second and just say, you know, we still have the opportunity for the applicants to say, to come up, and so I don't know that it affects any of your questions if you hear their perspective of this, but if you want to continue, I'm perfectly fine to have you proceed.
No, I think these questions are best suited for Shanna and the attorney.
Okay, continue.
Okay, and I'm halfway through, okay. The applicant for the guest house, let's see, previously had a variance for FAR, okay? And the purpose was for extending the garage. That's correct so far, correct?
Mayor Rael, Trustee Benavides, yes, the variance related to the guest house structure.
The question is, did the applicant game the system? And this is a crazy thing to ask because I don't know if even if you gamed it, if there's a problem with gaming the system. I mean, we all game the tax code when we can. So if the true purpose of the variance was really for the guest house and not for the garage, would the variance have been granted? Now, this is an unfair question to you, but I want you to contemplate. So it'd only be speculation because you don't have that application in front of you to see all the information. But if you care to comment, I'll allow you to comment. If you think it's too much to comment, then you don't.
Mayor Rael, Trustee Benavides, I certainly can't speculate other than to say during both the variance and the conditional use discussion, there were many conversations about which one of these should come first, which one should the applicant be required to ask for first. And some zoning codes will specify that if a variance is required, you must do that before you get a conditional use approval or vice versa. Our code doesn't specify that, and so it was the decision of the applicant, perhaps on a risk-based analysis of which one would be harder to get, that they chose to go for the variance first before the conditional use.
Yeah, I mean, it does feel like maybe something was gamed, meaning if they had come forward with a request for a variance for a guest house instead of a garage, maybe it would have turned out differently. That's where I'm going with this. But I don't know what to do with that information because I don't have any documentation saying that that this was their true intent.
Mayor and Trustee Benavides, if I could address that. Obviously, I haven't seen everything, but the information submitted by the applicant has on it their site plan of everything they intend to do on the property before anything was granted. It had expansion, it had the guest house, it has a swimming pool. Everything they planned to do was on the material they submitted. The question of which they pursued first, I think was something was discussed.
Okay. That's important. That's important information too.
Yeah, there was no hiding the ultimate plan. They all appear on plat. In fact, I think you'll find it on the site plans in your packet.
Now, let me ask about precedent, because I think people are going to say that, well, I was denied, a guest house to a detached garage. Is there anything that's been documented that you could find that says somebody was denied a guest house to a detached garage because it was bordering, had a shared wall?
Mayor Rael, Trustee Benavides, no, I have not found written evidence of a decision of that nature.
No opinion was written about that.
Mayor Rael, Trustee Benavides, no. I have heard about conversations, but nothing in writing.
Okay, I think that's the end of my questions. Thank you.
Okay, we'll go to Trustee Ranovich.
Shannon, I actually do know of a house that has this same situation that was approved in the last 4 years, only because they asked me to do a landscape plan for them. And the guest house is attached to, it's in the village, we obviously gave them approval for was actually in the Home of Parades, and, or whatever it's called, the Parade of Homes. But it has a guest house that's attached to a garage that is not attached to a main house. So it's a very similar situation. I don't know if there was a house there to begin with, but it was approved by the village like that. And so it is a case in point. I just wanted to point out. So you said you did know of a couple other or another case that you didn't get a chance to tell us about. Would you do that now?
Mayor Rael, Trustee Radnovich, I am not aware of that example, so I would be interested to get that address from you at some point. In reviewing previous guest house approvals, I found two examples that are not identical to this one, and so it's not going to be an apples to apples comparison. When I referenced precedent in my staff report to the P&Z, I was referencing these examples. I did not go on to explain those examples. I just made the statement that my decision is based in precedent, period. And so if it's the will of the trustee to hear a little bit more about those two examples, I would need you to vote to allow me to describe those. I've got the addresses and a little description of how they're oriented and how they influenced my recommendation.
Before we go there, unless you all have a strong preference, I would say let's stick to the record for now, and let's let at least the applicants have their turn. And unless you all have any other questions related to this, Trustee Ryan. Okay. So with that, why don't we move on now to the applicant, Selena, and is it Dapo? Is that correct? If you all would approach the podium and state your name and address for the record, and you have 15 minutes to make your presentation.
Okay, thank you so much. My name is Walter Gill, and I am the agent for Dapo and Selena.
Hang on, Mr. Gill. Mr. Chappell, is the agent appropriate for this presentation?
Yes, and Mr. Gill actually made the presentation at the Planning and Zoning Commission.
Okay, thank you very much. I appreciate that.
Okay, my address is 912 Broadway Boulevard, Northeast, Albuquerque, New Mexico. I guess I have a statement here, similar to the conditional use hearing that I appeared at. There were some public comments, and I was able to address those comments with a kind of a response letter that I was able to present to Shanna, and she was able to kind of include that in the packet previously, and I wasn't sure about the procedures on a Board of Trustees meeting because I've never been to one. And so I wasn't sure if that was appropriate for me to introduce that letter of response to the appeal.
Ms. Schultz?
Mayor Rael, what Mr. Gill is referencing would be new material, new testimony, not, it's a letter distinct than what they provided for their planning and zoning commission meeting, and so the Board of Trustees would need to approve acceptance of the new material.
Of the new material, okay.
Yeah.
What is the pleasure of the board?
Are you just asking?
Yeah.
Would you consider accepting new material, or should we continue with the record and then make that decision after his other presentation? Would you prefer to do that?
I think the latter. I'd say the latter. Continue with the record. Yeah.
Would you just make a presentation on the record and then we'll
Sure.
consider that request
Okay.
after your comments?
Okay, so let me grab this. So, Mayor Real, Board of Trustees, members of the public, thank you. My name is Walter Gill with Modulus Design. I am speaking on behalf of the Tamori family, the property owners at 720 Mullen Road. The Tamori family returned to Albuquerque in 2024 to be closer to family. with the intent of building what they consider their forever home. We began the design process in the fall of that year with a clear goal: to create a home that meets their long-term family needs while fully complying with the village and county regulations. After careful review of the zoning code with the zoning department and exploring several design options, the project required two zoning actions: a variance for the floor area ratio and a conditional use approval for a guest house. From the very beginning, we have proceeded in good faith with full transparency. We initiated zoning actions in April of 2025, met with the former zoning administrator, Brennan Williams, and followed the recommended sequence. First, the variance to the floor area ratio, then the conditional use for the guest house. We attended multiple hearings over several months, responded to questions and public comment, and ultimately received approvals in August and in October of 2025. Throughout this entire process, the design, the drawings, the intent of the project have not changed. Both former and current zoning officials, including Mr. Williams and Shanna Schultz, reviewed the conditional use application and recommended approval. At no point have we attempted to conceal information, circumvent regulations, or expand the scope of the guest house beyond what was presented. There's no hidden agenda to enlarge or alter the function of the proposed guest house. Some public comment raised concerns about the village code provision stating that guest houses may not have a garage. I want to be very clear. The guest house does not have a garage. It does not use a garage. The garage shown in our plans only serves the primary residence. This is fully compliant with the code and the conditions on the conditional use approval. The intent of this provision is to prevent a guest house from functioning as a separate independent dwelling. Our design does not create that condition, and both zoning officials who reviewed the project agreed with this interpretation. We understand concerns about how future owners might use the property, but respectfully, zoning decisions must be based on the submitted design and stated use, and not speculation about what future owner might or may not do. No applicant can control future misuse. That is precisely why the village has enforcement authority to address violations if they occur. We must trust that the zoning department can enforce the village code. The Tamori family is making significant investment to build this home properly, legally, and in alignment with the village standards. We fully support the village requirement that guest houses and accessory structures remain subordinate to the primary residence. In this case, the guest house and garage are smaller in size and scale than the main home. They are visually subordinate, and the design respects the character of the neighborhood and the village. We recognize that some residents may have received different guidance in the past. While we empathize with that frustration, this application must be evaluated based on the current code and current zoning interpretation. This project has followed that process carefully and transparently. On behalf of the Tamori family, we respectfully ask that the Board of Trustees to uphold the conditional use approval granted in October 2025 in recognition of the thorough review, consistency, and good faith effort demonstrated throughout this process. Thank you for your time and consideration. The letter that I was wanting to introduce was really more or less a more detailed version of that statement there. And so I just kind of outlined our timeline of me working with the Tamori family, going through the process of all of the zoning actions that were required, and trying to respect truly the village code and master plan. You know, the master plan and the village code in Los Ranchos is unique and has, you know, their own requirements like any jurisdiction. And the one thing that maybe could be noted in that is the what was brought up in the appeal was the cluster house, the cluster housing condition. And so I do have a note about that I wanted to just quickly say, is that the land, and this was kind of something that was presented at the variance, the first zoning hearing. The land that includes 720 Mullen Road and all the immediate neighbors that are here, a part of the appeal, was annexed into the village of Los Ranchos in 1967 and zoned as a residential agricultural lot at that time. In 1986, the property was subdivided into more or less half-acre lots that were approved by the Village Zoning Commission under a cluster housing classification. The village values agriculture and open land as its core part of as its identity. Cluster housing allows for homes to be grouped together on smaller portions of property to allow for larger contiguous areas of agriculture or open space to remain intact. That's the reason for cluster housing. And also another thing that got brought up in the most recent conditional use hearing was one of the commissioners kind of did some research on A1 housing. And she found out that 60% of A1 housing, which is in the code, calls out for 1 house per 1 acre and can have a guest house if proper conditional use approval was applied. 60% of A1 housing is less than 1 acre. And many of those properties have guest homes. You know, the tricky part of this whole property is that, yes, it's a cluster house. It's a cluster housing development. So it is on a smaller lot. It's harder to organize forms, the use of the property, the site plan to work, and especially when you're using an existing property, existing structure. So this whole project is really a renovation and addition project, but it is a big picture project. And that was what we wanted to be very clear with at the very beginning, even when we first stepped in and met with Brennan Williams back in the spring of this year, is that we wanted to put all of our ideas down on paper and make sure that all of them meet the permeability requirements, the FAR requirements, and then also the requirements of the county once it gets past the zoning part of Los Ranchos. And so,
Okay.
yeah, but I believe.
All right, we have now Mr. Dapo. He and his wife are the applicants, is that correct?
Mayor Rael, Ms. Tamori did testify at the hearing. Dapo did not provide testimony nor written comment for the record at the hearing, so if he were to testify this evening, you would have to accept him into the record. That would not be the case for his wife.
All right, let me then ask the trustees if he has made the request to provide testimony. It is your all's call to see if you would like to have. We have 2 questions of additional testimony on the record. One is Ms. Schultz, basically explain two projects that we need to vote on, and Dapo's request to add additional information.
Mr. Mayor, if I may say something before your deliberations, I was overseas at the time. I was on Zoom for that. My wife was in this room, and I was on Zoom. So to the extent that I was following the hearings, I did participate. But it is true that I did not speak. I was out of the country.
Okay. I'm inclined to let both of that information on both sides in for the record, just simply because I think it's important to give folks an opportunity. But it really is, if you all are in agreement, we can give Dapo the opportunity to add new information. And Mr. Chappell, does that require a vote for additional information?
I believe it would be the best procedure, Mayor, to have a vote, so it's clearly on the record that you permitted it and what you permitted.
Okay. So let's have I would say I would entertain a motion to have Mr. Tomari present information, new information for the record, but I need a trustee to move that motion.
Go ahead, you want to make a motion, George?
I'll make a motion to introduce the new information. I'm of the same mind as you, Mayor. I think I'd like to hear everything that both the applicant and the neighborhood has to say.
Okay, do we have a second?
Yeah, I'll second that, but I'm wondering if we could do it more broadly. Do we have to do it on a case-by-case basis? Okay,
I would do it on a case-by-case basis.
okay, all right.
All right, any other questions? No? All those in favor of, we have a motion and a second?
Yep.
Right? Yes. Do we have a voice vote, or do we have a roll call? Okay, all those in favor of permitting additional information by Mr. Tomari signify by saying aye.
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 Opposed, same sign? Okay. Mr. Tomari, you have the opportunity to present your,
Mayor Rael, I'm sorry to interrupt. A point about the time clock.
right, I was about to
It
ask the same
was
question.
at about 5 minutes when the Board of Trustees started deliberating their motion. So Darnell, if you're able to put, it was like 4 minutes and 57 seconds back on the clock to make sure that the applicant gets their full 15.
Okay.
Thank you.
Thank you, Ms. Jones. Thank you,
Right.
Mr. Mayor and Board of Trustees. Good evening. I have some prepared remarks that, but before that, I had some procedural issues that I wanted to speak to earlier on. And we appreciate that Ms. Kiefer has recused herself, as she should. But she made it clear that she has a personal and vested interest in the outcome of these proceedings. And so the procedural concerns we have to do with conflict of interest and ex parte communications. It's very clear, given her stated for the record interest in the matter, that the risk of ex parte communications is quite high. I want to note, because it has not come up so far, as I could tell, that Mr. Neil Kiefer is married to Trustee Jennifer Kiefer. As well, the lead appellant, Clinton Beebe, is believed to be Ms. Kiefer's father. These close familial relationships have not been previously disclosed, and they clearly create a concern about ex parte communication. I want that to be entered into the record. Now, I want to offer some comments in response to the appeal of the Planning and Zoning Commission's conditional use approval of the proposed guest house at a home at 720 Mullen. You have heard the assessment of the village planning and zoning professional staff, along with our design intent and application process with the village. I will focus my remarks on how we have experienced that process. While we might have reasonable discussions about code interpretation and sustainable development, this is not some commercial development. This is not the palindrome project. All right, we're seeking to repurpose an existing structure on our property to more efficient use without increasing density by building yet another structure. It is a low impact, fully compliant conversion of an existing structure into a guest house. It was approved by the Village P&Z Commission because it is compliant in every respect with the guest house conditional use ordinance and other pertinent zoning and planning requirements. There is no precedent being set here. Like all of you, we love and appreciate this community. We would like to preserve the community character just as much as you do, and the idea that we would be inconsiderate of the appellants and their well-being is deeply bothersome to us. The appellants own property adjacent to ours, as they've noted. While we respect the concerns raised in the appeal, it is unfortunate that some of the assertions are factually incorrect and misleading. To dispel any notion that we must be evil neighbors to warrant this degree of relentless and sustained efforts against us, we are a friendly, easygoing, and law-abiding family with valued friends in New Mexico and around the world. Like co-appellant, Mr. Neil Kiefer and his wife, Trustee Kiefer, We also moved to Los Ranchos to be close to our family. We have lived in a few states in this country and abroad. We have never had any issue with our neighbors. To be clear, in the year and a half since we have been at this house, we have had no direct engagement with the appellants, either in response to public notices on this matter or in any other significant context, since their preference seems to be to engage in public comment rather than seek meaningful dialogue and clarity. We have taken all their concerns seriously and have promptly responded in writing to all the issues they have raised through the village P&Z staff. The claim that the guest house is improperly attached to the garage was not raised before the Planning and Zoning Commission and is not part of the record. The commission reviewed the site plan as submitted, staff found it compliant, and the permit was approved based on that record. New issues cannot be raised for the first time on appeal. Their initial objection to the entire project was purportedly about procedural order. Should the variance come first before the code? And they made a big issue out of that. Then they, at the time of the CU application, they were in opposition to the guest house. They did not want the guest house. Of course, that has changed now. Now the issue they have is with the adjoining wall. We are left with the impression of different tactics at every opportunity, hoping that something sticks and they get the desired delay or cancellation. The appellants claim that the P&Z Commission, quote, ignored unanimous neighboring opposition is misleading.
May I interrupt you, Madam Shanna? Are we over the time limit?
Mayor Rael, yes, it looks like we have hit the 15-minute limit for the applicant presentation.
Okay. Can you wrap up your?
Yes, I can wrap up. It's misleading that somehow all neighbors are opposed to us. This is more unanimous family and friend opposition rather than some neighborhood revolt, okay? And with respect to all the what-if scenarios that have been proposed, there are processes to manage that, right? And finally, I want to mention the issue of they allege that the process has been unfair to them. They're deeply frustrated. We have been at this since May because they have opposed us every step of the way, right? And the idea that the husband and the father of a trustee somehow are at a disadvantage, I'm not sure that's credible.
Okay.
Thank you very much. I appreciate it.
Thank you. All right, we are now back to the question of having our Shanna present the two other, if you will, examples. We would need a motion, as that would be new material as well. With that,
Did you want us to remain?
no, you can sit, and then if we have, you'll have a 5-minute rebuttal after the next conversation.
I'll make a motion to include the additional information that was not previously presented by Shanna, our planning and zoning director.
All right, do we have a second?
I'll second it.
All those in favor of the additional information by Ms. Schultz signify by saying aye.
Aye.
Opposed, same sign. All right, Ms. Schultz.
Thank you, Mayor Rael. Upon my review of this application, the first thing I did was look to previous approvals, previous paperwork at the village for guest houses and how those guest houses related to the garage because the clause is ambiguous. I did not find in any instance that a guest house was denied by the village because of the presence of a garage. There are denials for other reasons, but never related to a garage. Two credible approvals that I did find is first one at 1020 Ortega. And again, I'll reiterate that these are not apples to apples. It's not the same exact built form as what is proposed at 720 Mullen. At 1020 Ortega, there is an approved guest house where it is a detached building that has an exterior door that is 10 feet away from a 3-car garage. As a means to say that how could the village prevent the users of that guest house from not using that garage when the doors are pretty directly accessed to one another? It's one example. Second, 8727 Rio Grande. A guest house was approved on the second floor of an existing single-family unit. This is within the definition of a guest house that says it can be within the existing structure. That primary structure has a 4-car garage on the first floor. There was nothing from preventing the user of that guest house from parking in that garage, entering the main house, which they would have to do anyway to get up to the second-story guest house. These were two examples I looked at to say, how has the village interpreted the presence of a garage on the site in relation to a guest house? That helped inform my decision that I think those are actually two more egregious examples of garages that could more directly interact with a guest house than this one. In future staff reports, I will outline those examples more explicitly instead of just saying there's precedent for me making this interpretation. So apologies that I didn't have that information in my initial staff report, but that is what I have to share in terms of my comments about precedent.
Okay. All right, back to the trustees. Do you all have any other additional questions of the applicant?
I don't.
George?
All right.
I do not.
Now,
I've got.
go ahead. I'm sorry, trustee Renau.
And it may not be for the applicant, it may be for Shauna. And that is that when I took a look at the site plan, there was two things. One, that there was a FAR calculation that was, there was a variance approved on the 12th of August to increase the FAR, okay? Under what circumstance did that occur? Just so that I can understand it.
Mayor Rial, trustee Rynau, can you help me understand your question? Under what circumstance? The applicants applied for a variance to the floor area ratio, and that was approved by the Planning and Zoning Commission.
So, yeah, so then it then increased the FAR from 5,195 to 5,826. So that was the variance that was approved by the board by the commission at that time.
Mayor Rial, trustee Rynau, that's correct.
Okay. The other question is on the permeability surface calculation. It indicates here that 60% of the surface of the land is permeable. And I'm looking at the site plan, and I'm still trying to wonder how 60% comes up to what is currently being built. Because even if we look at the swimming pool as an example, which is not under consideration tonight, take a look at the fact that there's going to be a new driveway put in to the garage area. Okay, how do we come up with 60%?
Mayor Rial, trustee Rynau, good question. Kind of two responses. First being that the permeability calculation is not relevant to the conditional use approval. A conditional use is asking about the use of the structure. The applicants will have to come in for another application when they are ready to build that structure or renovate that structure. And that's when we do checks for floor area ratio, permeability, square footage, building height. That a question about how is the building used is not answered with permeability, FAR, et cetera. And I think this has been a little bit of a confusing point throughout this application that both their variance and their conditional use application showed kind of the full scope of improvements that they hope to make over time. They will need to come in for applications at each of those stages. For a new driveway, we will need an application. For a pool, we will need an application. And the village will check and recheck FAR and permeability at each of those stages to ensure compliance. And if at some point one of those stops, say, a future pool application puts them out of compliance with the permeability standard, we would deny that application. So I understand that concern. I think the point of the 60% is that the site conditions today do have a permeability of 60%, but I agree, just eyeballing the plans, that would certainly not be true if the site were to be fully built out as proposed.
Mayor, may I comment?
Sure.
In looking at the plans, you need to consider also that the FAR calculation is based on a different standard than the permeability. For instance, on one side of the lot, there is an easement, access easement that is part of the lot but is not used as a part of their access. FAR standards will not allow you to use the easement for determining floor area ratio. The permeability does allow use of the adjoining easement for permeability standards. So just looking at the plan, you can't tell which is which, and the reason it must be checked very carefully.
So then permeability then was not an issue that had been discussed at P&Z?
Mayor Rial, Trustee Rhino, I believe it was discussed at P&Z during both the variance and conditional use stages, but that criteria does not become relevant until they come through with a building permit request.
Okay. All right, any other questions?
I have a
Trustee Rhino.
I have a couple that are pretty minor questions maybe, but I'd like to ask them. Shanna, how do you define density in our code?
Mayor Rial, Trustee Radnovich, first I'm going to see if there is a definition for density, which I sure hope there is, but there is. Density means the number of dwelling units permitted per acre or part of an acre of land.
Okay.
Mayor Rial, Trustee Radnovich, the code goes on in certain places to use this metric, 10 dwelling units per acre, 5 dwelling units per acre, et cetera. Those are examples. That is not a criteria related to a guest house or a conditional use.
Got it. Got it.
Okay.
I have other questions, but my computer's frozen. So I'll ask them. Will this be the only chance we have to discuss?
Trustees, we still have 5 minutes for each side to
Rebuttal?
to make a closing comments. So if you would prefer, we can go to there and then come back and have more conversation.
Thank you, Mayor.
All right. Well, let's just go ahead and go. I'll start with Neil, since you made the presentation on behalf of, do you want, you have 5 minutes for closing remarks?
Thank you, Mayor. On the closing remarks, I would like to point out, we actually did submit additional information for this appeal. I understand some of that was new, but in light of everything that's been offered today, I would request that the information that we submitted, that the Planning and Zoning Director decided not to include, which I agree, there was maybe some pieces that were new, to see if I could actually quote the materials that we had provided, as it does provide a little bit more perspective as well in relation to some of the items. And then I do have a couple questions that I would have kind of posed as well.
In fairness, and Ms. Schultz, are we good with, we have a request to add those new material?
Mayor Rial, the appellant is referencing, I believe, their appeal kind of application that stated kind of a narrative of the grounds they were appealing under, and then several letters from residents or neighbors about their experiences trying to get a guest house permit in the village. We have those documents available. I think it would be appropriate for the Board of Trustees to vote to put those into the record if they so choose.
May I suggest to the trustees that we let that information for the record, but rather than go through it in detail, Mr. Kiefer, would you be able to summarize that for us in your 5 minutes in closing remarks?
Yes.
Okay, let's have a vote then to permit the new information. Do we have a motion to permit new information from the appellants on this matter?
I'll make a motion to hear new information from the appellant.
Do we have a second?
Yeah, I'll second that.
All right, any other questions? All those in favor signify by saying aye.
Aye.
Opposed? Okay, Mr. Kiefer, you got 5 minutes and.
Thank you, Mr. Chair. I do appreciate that additional research was done by the Planning and Zoning Director. I would be curious to just the 2 items that were reviewed, if she took into account anything within Caballero or Caballero Norte, as we do have multiple individuals that actually did state that they were actually not allowed to do this based on the requirement of not having an attached garage. So those statements were in the materials that were provided, where it was noted that at least 4 people were denied. There was a couple others, another one that did state that they were not allowed, as well as another one providing comments. So there was other people outside of just the neighbors that were discussing this particular topic. I will say to Mr. Dapo, and I do apologize, I hope that, I know this is always tough when we have different opposing opinions. And I do put it out there that, if they wish to discuss this, there are 2 sides to it. I will say that we didn't reach out to them, but I don't believe they've actually reached out to us either. So, it does work both ways. But I do appreciate that they came to the village. I'm glad that people can come here and enjoy it. So I just want to make sure that I do clarify that it has nothing in regards to, taking advantage of this beautiful community. Some of the things I would like to state, and I would question, I guess, regards to the properties. I just want to clarify that they were within the last couple of years, if that's okay to ask that question.
Go ahead.
Mayor, I'm not sure that the applicant is in a position to ask staff and council questions as a part of their presentation.
State your perspective, and we'll take that into consideration.
Yes, if this had been in the board packet, I would have had time to prepare to decide whether, or to look at it to see as far as the time frame. A lot of this is relevant based on when the code was written, because you have to look at the code and also have to look at when these were approved. Just like any other statute, you could have grandfathered in because of when the ordinance may have been, in this particular case, was put in. So the question is when did the ordinance go into effect? And when did these properties take, I guess, have this where they were built and structurally attached to it? So not just the bearing of the question is whether to know what the timing was, because that has a bearing on ordinance and code as it's evaluated.
Sure. Okay. All right. No, I appreciate that. Is there any other remarks you'd like to make in closing?
Just a couple other things that I would say, as I did make good things here as far as it. I know that it does say current code interpretation has been brought up, that it's been ambiguous, and that's why I think precedent really comes into this. A lot of times when it is ambiguous, you have to look at other materials that you have. Do you have this documented anywhere else outside of ordinance? And I think in this case, that's where this question is coming down to, is where precedents. I think I'm bringing up, and it was mentioned during the planning and zoning, where they specifically noted Caballero Norte, as far as having guest houses. We're not just denying that they don't have guest houses. That was clearly stated in there. We agree with that. The question is actually true to the ordinance, is whether or not they can be attached. And that's one of the questions there. The other thing is the notion, I know they were talking about repurposing, they were talking about a lot of items. We're not trying to, once again, deny the guest house. They, more than happy if they build a guest house. We were just saying, following the code, that's where it stipulates. I do know that there's only a minute 23, and I hate to take all the time over my other colleagues in case they have any other statements. But I do know that obviously the planning and zoning, it's one of those advisory committees that makes the recommendation. It is really up to the board that has to make this decision. If it is, if you did want further testimony of the individuals that were in the packet that we submitted, I know some of them are here in attendance, maybe or maybe not, they want to speak. I don't want to put them necessarily, in the point of feeling uncomfortable unless they wanted to say something. But I do know individuals that did support this packet are here in attendance.
All right, thank you, Mr. Kiefer. Do we have any questions, Mr. Kiefer? All right, let's move on now to the applicant. Mr. Mario, would you like to have 5 minutes for closing?
Good evening. My name is Selena Tamori, and I live at 720 Mullen. Thank you, trustees and mayor, for listening to our position this evening and for all of your thoughtful questions. I just wanted to state a couple things. One thing that wasn't mentioned earlier, as a part of this appeal process, it has come to our attention that appellant Nancy McCoff addressed this matter publicly in unsolicited comments on October 21st to the Board of Trustees after the Planning and Zoning Commission decision on October 14th. We respectfully raise this as a potential ex parte communication. Because any arguments, facts, or information presented to the board outside of the formal P&Z record may inappropriately influence the trustees. The village rules and administrative law principles require that the board base its decision solely on the record before the P&Z Commission. And consideration of this communication without formally incorporating it into the record could violate procedural fairness and due process, creating grounds for challenge. These measures are necessary. We request that the board confirm that no trustee will consider any ex parte communications. We would also ask that the board here today limit its review to the administrative record before the P&Z Commission. And if the board receives any additional information that is not already in the record, we ask that we have access to that and that we may be able to respond to that. Again, we want to thank you for your attention and for your questions, your thoughtful questions. And we ask that you uphold the Planning and Zoning Commission's decision in its entirety, denying the appellant's appeal. Thank you.
Thank you very much. Any questions from trustees? Okay. Let me make just one comment, and I'm going to, at the risk of trying to get to a decision, Mr. Kiefer, you've made two comments in your first presentation and then your follow-up that you all are not opposed to the guest house. If this guest house was to have been built with a separate wall from the garage, would we be in this situation?
Mr. Mayor, I don't believe based on the code, if they were not connected, we would not have an argument here to bring this forward to the group.
All right.
It is based on what the ordinance is, and obviously they would still have to follow the FAR and permeability, and I don't think that's what we're discussing today. That would be something that would come through later process, so. Maybe depending on what those entail, I don't know. But we're just saying based on your question, based on that, the guest house, it says everybody can have a guest house, so we're not arguing that.
Okay, thank you. Any other questions for either applicant? No? So we need a motion, and I'm gonna ask, can you come up here and give me a second, because I got a little confused on what you wrote here. Oh, yes. I just want to make sure. Yeah. All right, sorry, I just wanted to make sure that we had a motion that we, on this issue. So we need a motion to move this item. Just for the trustees' information, we can have a motion to affirm the original decision. We can have a reverse the decision, which would be to deny the appeal. We can modify the decision, or we can remand the decision. These are the, if you will, the breadth of our decision perspective here. So, do we have a motion from the trustees on this matter? Trustee.
Mayor, I may have missed my opportunity, but I do have one more question. It's a minor question.
Okay, go ahead, Trustee.
Ms. Schultz, there's a list at the end of, a list of people at the end of the, it's on page 93, and many more people that are here tonight. What is that list? What's the relevance of that list to the case? It's on page 93.
Mayor Rael, Trustee Radnovich, thank you for the question. Everything that's got that header that says this was included in the staff report from the October 14th hearing in which this document is included, this was the list of mailing addresses in which public notice was required to be sent per the code's 300-foot requirement.
I see. Thank you. That's the only question I had, Mayor.
Okay. All right, do we have a motion on this matter?
I'd like to make a motion to approve, let me see if I can go back to the case number. Apologies. Yeah, to the case number CU-25-03. I'd like to make a motion to refuse the appeal.
To deny.
To deny the appeal. Thank you.
Okay.
All right, do we have a second?
Sure, but that, I understand what he wants to do, but that's not the verbiage that was given to us as options. Is that okay?
Affirm or reverse would be the same as deny. Is that correct, Mr. Chappell? No? Okay, I apologize.
I think, Mayor and trustees, I think the proper wording is a motion to deny the appeal, which means that upholds the decision of the Planning and Zoning Commission.
I will second that.
All right, we have a motion and a second on, to deny the appeal. Any additional conversation?
I wanted to revisit, before we take a vote, if we could, on the, on the discussion that you just had, Mr. Mayor, about modifying the proposal so that the unit would be detached from the garage. You know, and I have, you know, in talking with people outside the village, not at all inside the village, but this issue's come up a lot, you know, and so I'd be a lot more comfortable if there was a opportunity to have a guest house that was totally separate from the active garage. And I wondered what other members of the board might think about us, again, modifying the proposal and requesting that it be modified in such a way to separate out the garage from the guest house.
So we have a motion to deny. If we want to reconsider that or have that motion, we would need to have basically the maker of the motion to rescind the motion.
Well, I think he wants discussion after the motion we made.
Right.
Which we could do, and then we can vote, right?
Okay, yes.
Yeah, I mean, do you want to comment? I can comment too.
Go for it, and then I'll follow you.
Trustee Benavides.
I would say a couple things about that. I'd agree with Shanna that it doesn't require it to be detached. And if we were to include that as a condition, I mean, what is detached? Does that have to be a foot away, or, I mean, all of a sudden it becomes an unworkable thing to build all that into that piece of property. And I would like to mention the notion of precedent. So I don't, I suspect if we were to allow people to come up and talk about, well, I was denied, right? I don't think we would find any documentation that would support that this is the application, this is what was considered, this is why it was denied, right? So I think the decision that if we were to approve the denial, those people that felt like they were unjustly denied, they can come before P&Z and get it approved now. Yeah, I'm totally aware of that. I don't think there's going to be a floodgate of that happening, but that, to me, that is their right now. And it was their right before.
Yeah, and I feel similarly. I do know of a case, and I'm happy to pass it on to you, Shauna, that a house that was added onto or built within the last 4 years actually won an award. And it's exactly the same situation. It's a garage that's attached to a guest house that the larger house also uses, which is separated. So I don't, the separation doesn't, I don't see what difference that makes. I mean, a separation of a demising wall seems like a pretty big separation. I get that the homeowner could in the future punch a hole through that demising wall. I understand that. They could also, if they were separated, in some point in the future, connect the two. So it seems to me that it's just not worth putting the family that's trying to do this in that position to make a change to the house plan. So that's yeah, I feel similarly.
Okay. All right. Are we, any other comments? All right. We are, for the vote, all those, this does not require a voice vote, is that correct? Correct. All those in favor of the motion signify by saying aye.
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 Opposed?
Opposed? Nay.
That motion passes on the 2-to-1 vote. Thank you very much. We are now moved to the next item on our agenda. Ordinance number 306. Approval to adopt an ordinance TA-25-02. Request by the Village of Los Ranchos de Albuquerque to amend the text of 9.214 Village Center Zone, 9.2.2 Planning and Zoning Commission, 9.2.3 definitions, 9.2.5 establishment and interpretation of zoning zones and character areas, to remove unused terms, modify existing formatting for consistency, and establish additional development standards, as well as create a new zoning designation, 9.2.14.5 core commercial zone with all applicable zoning requirements and regulations. We are now ask Mr. Chappell to swear in any individuals who will be speaking on matters on the zone of number 306, 307, or 308.
If you would raise your right hand, do you solemnly swear to tell the whole truth and nothing but the truth under penalty of perjury?
All right. Madam, we'll go to Shanna for an explanation of the ordinance.
The mayor and trustees, we have an issue. This zoning, although not materially, it doesn't appear like, but it does change the zoning on the palindrome site to some extent through the drive-through and that sort of thing. And so I think that the Board of Trustees needs to evaluate whether or not they are have a conflict and can vote on this issue.
Oh, I see.
So, Mr. Chappell, let me make sure I'm clear, or Ms. Schultz, in what context, since I was under the impression the entire project area was not impacted by this, by any of what we were doing tonight? Am I incorrect in that determination?
we just had a consult, and Ms. Schultz says that it went back to P and Z, and those things that made material changes in the VC zone were taken out of the ordinance. So that would resolve that problem if there's no changes.
Okay, great, okay. All right, let's go back. Thank you. All right, Ms. Schultz, go ahead and describe the,
Mayor Rael, Board of Trustee members, this is a proposed change to the village's zoning code that does primarily two things. It creates the core commercial zone district and associated standards, and it essentially consolidates the VC zone and the VC project area into one zone district that would just be titled Village Center VC moving forward. This is a companion piece of legislation to your next bill, which is a zone map amendment, which seeks to actually change the zone map to implement the CC zone district. The Board of Trustees held a special meeting earlier this month to hear kind of the first pass of these changes. There was quite a bit of discussion on the proposed text and the proposed changes from the Planning and Zoning Commission. I'd like to focus the conversation tonight on a set of amendments that have been drafted in response to that discussion that begins on page 114 of your packet. Before that, I want to mention that I've received one public comment about this item since the special hearing from Mr. Myers, who is sitting in the audience, related to the text in the CC zone district. There's a request related to the language about non-conforming uses. Mr. Myers, would you like me to present your comments in lieu of your request to change the zone map on the next item?
Yes, because if I don't change the zone map, then I might still have to.
Sure, yep, okay. So I received an email from Mr. Myers today. He represents a property owner who owns a drive-through in, on a piece of property that is proposed to be rezoned to CC. If it gets rezoned to CC with the changes as they currently sit now, that drive-through would become legally non-conforming. Drive-throughs are proposed to not be allowed in the CC zone district. So Mr. Myers has made a request to add some language to the CC zone district that says non-conforming uses have 365 days to begin again before they are considered illegal. The way that the code works today is that when there's a legal non-conforming use, if that use stops, so in this example, say his drive-through tenant goes away, the code says you have 180 days to find a new tenant to retain that legal non-conforming use. After that 180-day mark, you are considered illegal. You can never get that use back. So it's a use it or lose it kind of thing. He's requesting that language go into the CC zone district to extend that time frame only for properties within the CC zone district to 365 days. Other than that, I'll stand for questions about the requested text change or about the packet of amendments that are labeled A through L.
before we go off of that, off the topic, if I might, members of the board, Shanna, who else is impacted in the CC zone with a drive-through like this at this point?
Mayor Rael, let me get over to my map. Yeah, the large bank that is on the corner of 4th and Osuna also obviously has quite a few drive-throughs. Those would also become legally non-conforming if converted to the CC zone district.
But,
excuse me, can we just make sure, that's right.
Mayor Rael, I believe the question of clarification is, was that change made only for food establishments? And I need to remind myself about how the Planning and Zoning Commission amended this item during one of their final hearings. So let me just navigate over to that text to be clear.
Yeah, for some reason, I think it was only for food is my understanding, but.
You're saying that there's drive-throughs for banks and Walgreens is not.
Is not impacted.
And auto-oriented.
And automobile-oriented kind of.
Mayor Rael, Board of Trustees, memory serves me correctly, there was a change by the Planning and Zoning Commission to prohibit all drive-throughs, no matter what they are associated with. There might be an amendment related to this for discussion this evening. Let me just take a look at my
So
table.
why don't we do this, while you're looking for that, since we have amendments already that we need to vote on, as you described them here on 114, can we, first we need a motion to consider the ordinance, so we need a motion for approval, to put it on the table.
Motion to approve ordinance 306.
Do we have a second?
I'll second it.
We have a motion and a second. All right, we have several amendments here that we should go through, and Shannon will consider that amendment as the last one, so it gives you a little time to review the. So our first amendment was raised by Trustee Benavides. And it's amendment, go ahead.
Thank you, Mayor Real. So again, this begins on page 114 of your packet, amendment label A. The first two are a request from Trustee Benavides. There was some narrative text about the intent of both of the CC zone district that really was just kind of nonsensical. And so I've proposed to strike a lot of the text that I think doesn't bear any meaning if it's removed, and I think that clears up some of the confusion, rightfully so, in that section.
Trustee Benavides, this was your amendment or your request?
Yeah, I mean, I'm supporting that we adopt this amendment. I just thought it was confusing language. That was my issue with it, and so thank you for fixing that.
Okay. Madam Chair, excuse me, Madam Clerk, we typically do a roll call vote on these amendments, is that correct?
Yes, Mayor, but before we continue, do you want to hear from any of the individuals who signed up?
Oh, I am so sorry, we just got ahead of ourselves. Let's go back then to the folks who have signed up. So thank you very much, Shannon, but let's go back to public comment. And I think, do we need to swear in, folks to speak on this?
We did.
Oh, did? Perfect.
Yes.
Wow. Go ahead, then let's call up our.
Mayor and trustees, the first individual who signed up prior to the meeting is Mr. Robert Chavez. If you would, please state your name and address for the record, and you have 2 minutes.
And I didn't mean to take, it's not that I didn't want to listen to you, Robert.
Please don't start the time. Robert Chavez, 324 Enchanted Valley Place, Northwest. Just very quickly, I'll make it quick. Mayor, trustees, staff, and residents, I would like to thank those individuals that served on the VC Zone Review Committee. These residents spent the better part of 2024 working on the changes you will hopefully adopt this evening. Mr. Hank Kelly, Mr. Jeff Phillips, Mr. Tom Donlin, Carrie Peel, Mr. Ron Chavez, and I want to thank the staff that was participating, John Avila, Mr. Brennan Williams. Mr. Chappell should be mentioned for his detailed work on the legal aspects of the new ordinances. Director Shanna Schultz for her work on the changes when she came aboard. Thank you. I also want to thank the trustee Renau for taking on the lead on this VC zone review after it was dropped during the Lopez and Craig administration change. We owe Frank our deepest gratitude. Thank you, Trustee Renau. I would like to make you aware that the committee recommendation had the 2 Chavez properties in the VC zone be moved back to C1 where they originally were zoned. The last BOT had a long discussion on this item, and hopefully when they come before the committee for C1 change, the P&Z, and then the BOT, that this gets approved and not forgotten. This process has been through 2 years of going through all of the steps, including 3 public meetings, 2 P&Z reviews, and 1 BOT. So I think it's time to get this thing done before the moratorium expires at the end of this month. And we are all in total support of 306, 307, and 308. Thanks for your consideration.
Thank you.
Thank you so much. The next individual is Mr. Matt Myers, if you would.
Hi, Mayor and Board of Trustees. Matt Myers. Should I give my address? 1401 Central, Suite B, Albuquerque, New Mexico, 87104. And I'm here on behalf of the property owner at, it's the Federidelfos and the new development just to the south of Federidelfos, as well as the portion of the shopping center to the west of the Walgreens, not including the Walgreens, to the west of the Walgreens. And that's the Peterson family. It's different entities, but the addresses are 6601 4th Street. That's the furthest west of Walgreens. 404 Osuna, that's the Federidelfos, and 6561, that's the new development just to the south of Federidelfos. Ms. Schultz already told you a little bit about the change I wanted to see in the core commercial zone, and I let her do that because she's so eloquent and everything she says always makes good sense. So she already said that. Specifically, what I wanted, I had a concern, 2 issues. Number one, I would like to have the aforementioned properties remain in the village center zone. That's one of my requests this evening. Alternatively, if the properties cannot remain in the village center zone and they are rezoned to core commercial, the big concern for my client is obviously the drive-through, the food service drive-through at Federidelfos. It seems to me, and I haven't gone through every single property, it is the only food drive-through within the core, what will become the core commercial zone. So we can't help but feel as though we were being singled out when it was my understanding that it was only food drive-throughs that were going to be prohibited in the core commercial zone.
The speaker's time has expired.
Go ahead.
Thank you. It sounds like, and I'll make this quick, it sounds like I might be confused about that. Maybe it was all drive-throughs. But if it was only food, then my client's approval would become non-conforming. Pursuant to village code, my client, if it lost its current tenant, would only have 180 days to get a new tenant in there, or it would lose the conditional use. 180 days is not a long period of time to find, it is a very short period of time to find a new tenant, to make any interior changes, to get the new tenant in there, to sign a lease with the new tenant, to get the applicable approvals. So if my client's property remains in the CC zone, or what becomes the CC zone, I would ask that the change be made that I submitted to Ms. Schultz that would allow 365 days before the non-conforming use is lost. And those are my requests this evening.
Thank you very much. Okay.
With that, Mayor, that concludes those that signed up to speak on this item of business.
Go ahead.
I just have a clarification if I could. And this may be for you, sir.
Yep.
Your properties that you're representing include the Northdale Shopping Center, including the small strip center to the south of
Federidelfos, yeah.
Federidelfos, and Federidelfos. It doesn't include the other bank, Bank of America, that is north of that.
Correct. You have it exactly right.
The Walgreens is the demarcation.
Exactly.
Okay, thank you.
Yep, thank you.
Thank you, Mayor.
All right, sure, thanks. All right, let's go back to our amendment, since we've got him here, and then we'll address that one at the end of so that we can stay sort of on task. So there is Amendment A that Trustee Benavides presented. And so Trustee Benavides, would you like to move Amendment A?
So you're looking for a motion?
Yes, motion to, yes.
I can make the motion, right?
Right, yeah, absolutely.
So I will make a motion to approve, I think we said it's Amendment A?
Yes, on
Yes.
page 114. right.
Motion to approve Amendment A. Okay.
Do we have a second?
I'll second it.
Sorry. Okay, moving to second. Any discussion on Amendment A?
I'm just trying to understand what it's doing. Is it just removing that red part?
Mayor Rael, Trustee Kiefer, yes. Anything that's in red that is stricken out is proposed to be removed. Anything that is in red and underlined is proposed to be added.
Okay, great.
Okay. All right, any other questions? Seeing no questions, all those, absolutely, Ms. Clerk, to read the roll.
Thank you, Mayor. Trustee Benavides?
Yes.
Trustee Kiefer?
Yes.
Trustee Ranovich?
Yes.
Trustee Reinao?
Yes.
Motion passes 4-0.
All right, we'll go now to item Amendment B. Trustee Benavides.
Similarly, I was wanting to eliminate confusing language and either eliminate it completely or add additional text that made it clear what was being said. So I'm happy with either one. It looks like you chose just to eliminate it. Is that?
Mayor Rael, Trustee Benavides, this relates to text on page 107. There's a paragraph that has a lot of stricken through text and underlined text. It's adding and taking a lot of text from a paragraph. It's very confusing, and so I proposed we just scrap that in its entirety and start from scratch with the paragraph that I wrote so we can understand cleanly what the final verbiage is supposed to be.
And this is the clean version, correct?
Trustee Kiefer, that's correct.
And would you please read that so that folks in the audience at home can also?
Absolutely. This relates to the intent of the Village Center Zone. This paragraph would read, in the Village Center Zone, the village will encourage the types of development envisioned and may control development parameters by requiring economic development plans, entering into development agreements, and, to the extent the land may be owned or controlled by the village, by the filing of covenants and restrictions dealing with development and use of the land in addition to the zoning ordinances. All lands in the Village Center Zone will be subject to all requirements previously applicable to project area. This is the spirit of what that very confusing paragraph was trying to say, but it says it in a way that you can read with normal human language.
Yeah, thank you for the clarification, because I think I misstated it. So what you see in Amendment B is a cleaned up version, yes, thank you.
All right, do we have any, you want to move that amendment?
Motion to approve Amendment B.
Do we have a second?
Second.
All right, do we have any discussion on this amendment? This is a very important amendment, my friends. Want to make sure we look at it very carefully because it will encourage the types of development envisioned and may control development parameters by requiring economic development plans, entering into development agreements, and to the extent the land may be owned or controlled by the village, by filing of covenants and restrictions dealing with development and land use, in addition to the zoning ordinances, et cetera, et cetera. I think it's a good amendment, so I think it's the right thing to do. However, I do want to make sure, Shanna, that we don't lose, that we adopt it tonight and that we don't come back and visit on this, because there are some things here like covenants and other things that we have to develop down the road on these projects, and that we don't just sit here and then all of a sudden someone comes in with a project and we haven't developed what we want to happen, similar to what we had in the past. So I just want to make sure that we're not, but I do think this is the right approach.
Mayor Rael, I think something to note is that this is intent language. This is not regulatory in nature. Right. So this is trying to kind of paint a picture of what the village envisions for this zone. So this language is not necessarily binding, but it does give guidance for how the village wants to and will develop such properties.
Yeah, we know there's a lot of roads paved with intent, for sure. So anyway, having said that, do we, Trustee?
Quick question then, Mayor. Glad you said that, Shauna. So any guidelines in terms of creating a site development plan, we can discuss at a later date?
Mayor Rael, trustee Radnovich, that's correct.
Okay. Thank you.
All right. Having said that, no other discussion.
There's not to be anything, changing anything in the VC zoning that was to be included in this amendment. And this changes the VC zoning.
Mayor Rael, I can address that. The Board of Trustees and the Planning and Zoning Commission, which is what they had done, which necessitated the remands, made substantive changes that changed property entitlements. Intent language, legislative language like this does not change the entitlements of a property owner. I'm comfortable including this because of that reason.
Okay. Any other questions? All right, hearing no questions, Madam Clerk, to read the roll.
Trustee Benavides?
Yes?
Trustee Kiefer?
No.
Trustee Radnovich?
Yes?
Trustee Reinell?
Yes.
Motion passes 3-1.
Okay, we'll go now to Amendment C. Trustee Kiefer?
Yes, so somehow, some way in the core commercial zone, fireworks stores were banned, both temporary and permanent. And one of our largest businesses is Gemini Fireworks. And so I wanted to make sure that we protect their existence. They've been, they're a big business for us here in the village and occupy a lot of space. So wanted to change that to permissive. Now, I am up for, you know, if we want to separate temporary and permanent as discussion, you know, because I don't know if we want a lot of tents, you know, temporary fireworks stands. I don't think we have the problem because we do have Gemini, so I think it kind of keeps the competition down. I'm willing to have that discussion, but I do think we need to protect the business, the permanent business.
Ms. Schultz?
Mayor Rael, I don't have any further comment. I think Trustee Kiefer described the issue well. It's a policy discussion on if you want to nuance out temporary versus permanent.
Trustee Radnovich?
I have no questions.
So let's just make sure we understand what the amendment is. The amendment is?
The amendment is to remove it from not allowed to permissive use.
Okay.
For both temporary and permanent.
Do we have a second?
I'll second it.
Okay. Any discussions?
Yeah, and just to be clear, if we were to not, to leave it where it's not permitted, Gemini Fireworks would be allowed as legally non-conforming? Would that
Mayor Rael,
happen?
Trustee Benavides, that's correct.
So by making it permissive, then we allow other firework establishments to come in.
Mayor Rael, Trustee Benavides, correct.
And that was not your intent, or you're not worried about it, is what I hear, right?
I'm not too worried about it because I don't think there's enough competition with Gemini here. You know, what I'm saying is we can separate temporary from permanent, but I do think we need to protect the permanent structure and business of the fireworks store we have.
If I could, Trustee Benavides?
Go ahead, Trustee.
Yeah,
Radnovich.
Mayor, help me out.
Why can't we just strike the part about temporary from the code?
Because what happened is it got changed in planning and zoning to not allow. So that's the big difference. So now we're changing it from not allowed to permissive, back to permissive as it was.
Yeah, see, I have my interest. I'm fine with keeping our fireworks store in business.
Yes.
I'm just concerned about the temporary fireworks. And only for lots of reasons, but mostly because. But then I also recognize that this only has to deal with temporary fireworks within that area that we're discussing tonight.
Mayor Rao, correct. This is only
Right,
within the
so-
CC zone
Yeah,
district, so
CC
this
zone.
wouldn't regulate temporary tents in the rest of the village.
All right, so I don't know, maybe that's not as big a concern that now that I just thought about it
I
out
don't
loud.
think we've really seen them, have we? I mean, not that I,
Haven't we down at Smith's? I mean, it's not in the village.
but that's what I was gonna
but-
say, Smith's
but
isn't in
it's
the village,
pretty
so.
close.
Okay. So trustee Benavides, any other comment? No? All right. Anyway, trustee Rao, any comment? No? All right. Go to the vote. Madam Clerk.
Trustee Benavides.
Yes.
Trustee Kiefer.
Yes.
Trustee Ranovich.
Yes.
Trustee Rhino.
Yes.
Motion passes 4-0.
All right. We'll go to item D. Trustee Kiefer.
Oh, goodness, I've gotta remember this one.
Mayor Rao, Trustee Kiefer, may I,
Yes,
may I explain?
please.
Thank you.
Yeah.
There was a conversation at the last hearing about buffering requirements between commercial and residential. So this proposed amendment does two things. One, I believe that this was an omission in the drafting. I confirmed this with the person who drafted it. The proposed CC zoning district had no landscaping requirements at all. And so this creates a reference to the landscaping requirements in the code to make sure that we can require landscaping. So that's number one. Two, it specifically calls out, there is a buffer landscape requirement in 9219E that addresses the interaction between a commercial property and a residential property. So that is proposed to be referenced directly in the CC zone district to ensure compliance.
Is it E or F?
9.2.19E is the buffer landscape requirements. What's referenced in the line above that is 9.2.19F,
Oh, okay.
which is related to landscape
The
maintenance.
landscaping. Okay. All righty.
That,
Trustee Kiefer to move
that
the amendment.
covers what I was looking for. Thank you, Shanna. So I move to pass Amendment D, landscaping regulations for the core commercial zone.
Do we have a second?
I'll second it.
All right, any other discussion on this item? Madam Clerk, to call the roll.
Trustee Benavides.
Yes.
Trustee Kiefer.
Yes.
Trustee Ranovich.
Yes.
Trustee Rhino.
Yes.
Motion passes 4-0.
All right, move to item E, amendment number E. Trustee Ratnovich, Ms. Schultz to explain.
Mayor Royale, now comes the conversation about drive-throughs. I need to correct what I said before. I think I confused everyone. Drive-throughs associated with services are proposed to be allowed in the CC zone district, except that Trustee Radnovich's amendment before you right now proposes to prohibit them. So the way that the code is written right now, you could have a drive-through with a bank or a pharmacy. The proposal in Amendment E is to disallow that.
For some reason, I recall we had a conversation.
And if I could explain,
Trustee Ratnovich.
so I'd like all of the trustees to think about places that are village centers in towns and villages and maybe even cities around the state. Think Taos. Think Santa Fe. Think even Espanola, or Truth or Consequences, or Las Cruces, oh, not Las Cruces, Mesilla. You don't see drive-up facilities that are car-centric in the best of the villages around the state. You just don't see it. And there's a reason for that. You want to make center city, I'll use the term, or center village, a walkable, not car-centric, but a walkable place. Now, granted, we do have cars in our village center and lots of them. But anything we can do to reduce the influence of automobiles in that village center, I think is a positive. Now, banks are already there. Those are the only ones that really, and except for, I'm sorry, I don't get their name right. Thank you, Federadelphos. That is a really hard name to remember. I get what their lawyer is saying about it, but it does beg that question. And I will also say that at one point in time, Frederick Delfo's location was actually considered by the village of Los Ranchos in an approved plan to be the plaza for Los Ranchos with Chavez Road and I guess the part of Chavez Road that makes the S-turn through the Peterson property, and then 4th Street, and then a connection so that it would act like Santa Fe's Plaza with cars going around in one way, or even actually Old Town Albuquerque. So I realized what impact that would have on Frederick Rodolfo's, and maybe there's a way we can work around that, but I'd sure hate to see other drive-throughs approved in that area because it destroys what we're trying to do by having a village center in the first place. That is why I proposed this. So, thank you.
So those drive-throughs that are there now would be adopted as legally non-conforming, correct?
Yes.
I mean, so I think about Walgreens, right? I mean, if there was not a Walgreens and Walgreens wanted to come in and they wanted to do a drive-through for prescription, I think people want that, especially if you have mobility issues, right? And drive-up banks, tellers,
I separate.
Those are pretty popular things.
No, I'm saying that allow the banks, even a drugstore drive-through makes sense based on what you just said, trustee, because it's a different kind of service. It's not fast food.
Okay.
Mayor Rael, trustee Radnovich, I think I need a point of clarification then, because what's in front of you, absent any amendment, is allowing a drive-through associated with a service, bank, pharmacy, that's okay. What is proposed to be disallowed without any amendment is a drive-through with a food establishment. So if you are okay with banks, pharmacies, et cetera, you should not move your amendment. Your amendment would disallow a drive-through associated with a service.
I see. Thank you for the clarification. Then I'll withdraw it at that point, yeah.
Thank you. I was about to say the same thing. Thank you, Shanna. Let's move on. Number F. Trustee Ratnovich, that's yours too, my friend.
It is.
Mayor Rael, trustee Radnovich. The next couple are trustee Radnovich's, and they are design-oriented changes. The first one relates to covered patios. There's a proposed regulation in CC that says covered patios must not extend beyond the one footprint.
Yeah, those language is a little weird.
Yes, I'm sorry. Let me scroll up to make sure that that is correct. It is not correct. I'm gonna read the proposed language to be stricken as it should be written. Covered patios must not extend beyond the footprint of the first floor except where a building abuts 4th Street. That first sentence is proposed to be stricken, which would allow covered patios to extend beyond the footprint of the first floor, regardless of the patio's location.
And my reasoning there is, say a restaurant or say a facility like Kelly Joe's wanted to have a little courtyard where they serve food or wine and wanted it to be covered. It creates a better space for people to be in, beyond just the footprint.
Would you like to move your amendment?
Would I like to?
Move the amendment.
Oh, yes, yes.
All right.
Mayor Rael, trustee Radnovich, I would just request that you move the amendment as the planning director read it into the record to correct my typo in what's in your packet.
Yes, yes, thank you.
All right, do we have a second?
Second.
All right, it's been moved in second. And does everyone understand the amendment as Ms. Schultz read it?
A quick question. Okay.
Quick question.
So how about public right-of-way? I mean, are we talking about, you said without any regard to setbacks, right? Sidewalks and things like that, right? I mean, where do you draw the line as to where it can extend?
Mayor Rael, trustee Benavides, a private property owner could never build within the public right-of-way unless there's a revocable permit or some kind of approval from the village.
Okay, so this does not supersede that.
Mayor Rael, trustee Benavides, absolutely not.
Okay, and I'm okay.
Okay. All right, Madam Clerk, to read the roll.
Thank you, Mayor. Trustee Benavides?
Yes.
Trustee Kiefer?
Yes.
Trustee Ranovich?
Yes.
Trustee Rydell?
Yes.
Motion passes 4-0.
All right, we're going to item G. Ms. Schultz, please explain item G.
Mayor Rael, this is a proposed change to shade requirements in the CC zone district. Right now, the code says that shade shall be provided for a minimum of 50% of a pedestrian or bicycle path. The proposal from trustee Radnovich is to up that to 75%.
And Mayor, trustees, my reasoning there is the more shade we can provide to people to make it a more comfortable walking environment, the better. And this would align more with the city of Albuquerque's code and the city of Santa Fe's code, which try to provide more shade for a walkable part of the community.
Okay, does anybody have any questions on this?
So then is the shade provided then by the village, or would the shade be provided by the owner?
The owner.
Property? Okay.
This is all for private.
And the shade can be in different forms. It could be man-made structures or trees.
I guess.
Mayor Rael, trustee Benavides, that is how I would interpret that requirement, that they could delineate tree canopy shade on their site plan. They could show where they're putting up shade sails. There's a variety of ways to meet shade as a requirement.
All right, and if they put young trees in that will eventually mature to 75%, that's okay, right?
Mayor Rael, trustee Benavides, yes, that would need to be called out. We would want to see the shade canopy at the point of maturity, and then it would be incumbent upon the village to make sure that that landscaping plan is being met and maintained in perpetuity.
Okay. Just one question, Shanna, on this. Do we actually have anything in the books on this issue?
Mayor Rael, what do you mean by on the books?
In terms of, in our code, do we have a requirement?
Mayor Rael, the requirement today is, the proposed requirement is 50%. So this is just changing the number that already exists.
So 50% is what we have to. Okay. Any questions on this? Trustee Ranovich, to move the amendment?
I'll move that we accept the amendment to increase the amount of shade by increasing the minimum to 75% along pedestrian paths and bicycle paths.
All right, do we have a second?
Second.
It's been moved in second. Any other conversation? All those in favor of the amendment?
Yeah.
Clerk tell you.
Thank you, Mayor.
Have the clerk tell you.
Trustee Benavides?
Yes.
Trustee Kiefer?
Yes.
Trustee Ranovich?
Yes.
Trustee Rydell?
Yes.
Motion passes 4-0.
All right. Trustee Ranovich, item H. Ms. Schultz to explain.
Mayor Rael, trustees, this next amendment relates to if a development is choosing to provide park space as a part of their development, perhaps that's to meet the landscaping requirement, et cetera. There's also a shade requirement associated with anything identified as park space. Right now, that requirement is written as 20%. Trustee Radnovich's proposal is to up that to 50%.
Okay.
And it's the same idea to increase the comfort level of participants in that space.
Okay. Trustee Ranovich, move the amendment.
I'll move that the amendment H, increasing the minimum from 20% to 50% shade, be approved.
All right, do we have a second?
I'll second it.
Any other discussion? All right, Madam Clerk. to read the roll.
Trustee Benavides?
Yes.
Trustee Kiefer?
Yes.
Trustee Ranovich?
Yes.
Trustee Rydell?
Yes.
Motion passes 4-0.
Okay, move on to item I, Trustee Ranovich's amendment. Ms. Schultz to explain.
Mayor Rael, trustees, this relates to the glazing requirement in the CC zone district. Right now, it says walls that are facing 4th Street or Osuna have to have 30% of their facade glazed. That means windows, you can see through it. The proposal by trustee Radnovich is to exempt grocery stores from that requirement. So if a grocery store were to come in with a site plan, the village would not require the 30% windows along 4th Street or Osuna.
Okay. Would you like to move your amendment, trustee Ranovich?
Most grocery stores try to protect their stock, and so they have very small windows and banks of windows, or they're up at a high level where it's harder to break into. So that was my reasoning behind this, because for the palindrome project, one of the, their second, I'm sorry, the 4th, 5th, and 6th phase, one of their proposals was to have a grocery store there. And I think a lot of village residents would love to have a grocery store there. We want to make sure we can make it as easy as possible for them to have that.
Mayor Rael, trustee Radnovich, a point of clarification, that site will continue to be zoned VC, and this is a CC requirement.
Good point,
So
good
this would be
point.
applicable to any grocery stores that wanted to come into a CC zoning district.
Yes, and so it doesn't matter if it came there or another parcel, is what you're saying. Yeah.
Okay, would you like to move the amendment?
I'd like to move that we allow grocery stores to be exempt from the 30% glazing requirement.
Do we have a second?
Yeah, I'll second that.
Okay. Any other conversation?
Just a quick, you go first.
I'm sorry.
Trustee Kiefer.
Ms. Shanna, just for point of clarification, is the 30% requirement required in the VC zone since we're not making changes?
Mayor Rael, trustee Kiefer, yeah, that's a requirement today and that would remain untouched.
Okay, and I guess so it's really not gonna help us on the VC zone, right? Because the 30% is already a requirement. And I guess I'm looking from a uniformity perspective. Yeah, thank you. My words aren't coming to me that easy this evening. That if we have a hopefully grocery store in that area and it has glass and you keep driving and let's say there's little ones that come in, they don't, is that going to, from an aesthetic standpoint, look off or different? I don't know. I guess would be my.
They would look somewhat different. I don't know that would be an issue. I mean, in the olden days, but in the early 1900s, grocery stores, before there was as much crime and drive-through, windows kind of crime, they did have windows. But times have changed, and that's why grocery stores really try to lessen the glazing that they have that makes it easy, makes them more vulnerable.
I guess I'm just trying to figure out what.
From an aesthetic perspective, though, I think is what you're asking.
From aesthetic, and also what's the purpose in making the change if it's really not going to achieve what your original intent was for lots 4, 5, and 6?
Well, it's possible, and this was my thinking, it's possible that a grocery store doesn't show up on lot 4, 5, and 6. I know that the village would like to have a grocery store, so extending that to other potential redevelopment lots seemed to make sense to me. And from an aesthetic perspective, I don't think it would matter a whole lot. What they did in Nob Hill, not a grocery store, but for an apartment building, or actually it's condos that have parking on the bottom floor, is they made it look like it was glazing, but there's a wall behind it, so it's protective. So something like that could also work, I suppose. And that would be legal, excuse me, that would follow code.
Mayor Rael, trustee Radnovich, it would.
So we can do something like that and just not have this, this design criteria. I was trying to make it as easy as possible for a grocery store to come in. is what-
Well, and this is your amendment, you know, I don't know that I will support it, but that's,
Okay,
that's what we're here for, right?
that's it. All right, any other discussion? Trustee Benavides.
So is it possible to change that glazing requirement at a future date? Or is it locked in with lots 4, 5, and 6?
Mayor Rael, Trustee Benavides, I believe changes to the VC zone district are on the table as a part of a separate review and approval process, separate application, et cetera.
Okay.
All right. Any other questions? If not, we'll call the roll.
Trustee Benavides?
Yes.
Trustee Kiefer?
No.
Trustee Ranovich?
Yes.
Trustee Reinell?
No. No.
Oh, wow. Comes to the mayor.
Mayor Rael?
No.
Okay.
Motion fails.
Okay, the next one has to do with the use of the word articulation as opposed to modulation. Articulation is generally accepted as the architectural term, not modulation, for this purpose.
So,
Okay.
trustee, oh,
A
sorry.
motion to move the amendment?
I'll move that we modify J to include the word articulation in place of modulation.
All right, we have a second?
I'll second it.
All right, Trustee Kiefer.
My apologies, Mayor. Trustee Ranovich, for definition purposes, they are the same?
I've never heard the word modulation used in this context. It's usually used in electrical and digital devices. So I have never heard it used that way.
Perfect, thank you.
Okay. Any other questions? Not, Madam Clerk, to call the roll.
Trustee Benavides?
Yes.
Trustee Kiefer?
Yes.
Trustee Ranovich?
Yes.
Trustee Reinell?
Yes.
Motion passes 4-0.
Okay. Item K.
Item K was to take out the metal wall panel architectural style, because we have some pretty nice looking buildings that use metal wall panels, both rusted and otherwise, all across the village and state for that matter. So I didn't want to exclude that. And actually, there's one in the zone right now, which is I believe their office is just south of Plants of the Southwest.
Okay. Let's move the amendment.
I'd like to move that we strike the metal wall panels from the appropriate architectural style materials.
Do we have a second?
I'll second.
All right, any other questions? Trustee Benavides.
So I see where you're going. There can be attractive metal panels, and then there can be very unattractive metal panels, right? And so we're already saying no aluminum siding. We got that part taken out. So we're talking about something other than aluminum, I suppose. So it can be attractive or not attractive. So how do we keep the non-attractive panels out?
I don't know that I've ever seen a non-attractive one that isn't either pro panel or aluminum siding or something like that. A non-attractive metal panel might be something to the likes of a pro panel or a roof used as a siding, or even that is really not.
Mayor Rael, Trustee
I'm having a hard
Benavides, to
time-
help answer
sorry.
the question, substantial renovations or construction of property along this corridor is gonna have to go before P&Z and BOT, at which point the architectural style and material is up for negotiation. And so you would have purview in the future over if you think a metal panel is ugly or not, or this body would.
Okay, all right.
Okay. All right, so we have a motion and a second. Any other discussion? Madam Clerk?
Trustee Benavides?
Yes,
Trustee Kiefer?
Sorry, my brain's thinking, if I say no, right, that's still allowing metal wall panels to come, which would still have to come before to determine whether they're pretty or not pretty, correct?
Mayor Rael, Trustee Kiefer, if you vote no, you are voting to keep metal wall panels on the list of
As an option.
prohibited materials.
As prohibited. Got it. So then, yes.
And Trustee Radnovich?
Yes?
Trustee Rhino?
Yes.
Motion passes 4-0.
Shucks, I didn't get to vote. Okay,
You had your one chance tonight, Mayor.
go to L.
We still have a lot more to
Yeah,
vote.
I know. Go ahead, Trustee.
L is to amend the table to include no more than 2 spaces per dwelling unit in this zone. Trying to limit the amount of cars people can own in a zone that's not Rio Grande Boulevard or one of the other zones that people have many cars in.
so you're saying no more than 2 spaces for the entire dwelling unit, regardless of how many bedrooms?
Yes.
Okay.
In this zone.
Yes.
Okay. All right, you moved your amendment? And do we have a second?
I'll second for discussion.
All right, it's on the table for discussion. Any discussion?
So,
Yeah.
so I guess my question is, and kind of point of clarification, Trustee Radnovich, in your intent, and correct me if I heard you incorrectly, the intent is to not allow more than, allow people to have more than 2 vehicles, but yet they can, right? So then, couldn't we end up in a parking shortage like we've experienced in the VC zone?
My goal is to reduce the amount of car influence in the VC zone so that it becomes more walkable. And having a residential space that allows 4 cars to park in it in the VC zone is
CC zone, right? 'Cause we're
egregious in
talking
my opinion because of all the concrete that would be needed that is car-centric. So what I'm saying is that we should restrict the amount of parking spaces per 1 bedroom, per 3 or more bedrooms in the VC zone, where we'll want a higher density of living and less car-centric place as our village center.
So, point of clarification, so you keep saying VC zone, but this is CC zone, right? Yeah, okay, I just want to make sure.
Yeah.
But I guess I don't agree that limiting parking is going to limit people having cars and needing the parking, right? Because I think a dwelling unit can have 3 bedrooms and we allow 1 car, but there's still, let's say, 3 adults living in there, which each adult has a car. So now where do the other 2 people park?
What we're trying to do, though, is create a place that is not as car-centric as the rest of the village. So I would surmise that people that choose to live there, that might buy a 3-bedroom apartment or loft or something like that, would know that to begin with and be the type person, be the type of family that would have less cars. So they're choosing to live in a zone that we're trying to promote as a walkable zone, not a car-centric zone.
I completely agree with your motive and your what we want to achieve, right? I just don't think that that's actually going to achieve it. I think it's going to become more problematic. And as a matter of fact, one of the things that I was going to recommend was changing the minimum to 1.5 per bedroom.
Why do you think it's problematic?
I think it's problematic because I don't think let's say landlord or whoever may be owning these properties and or renting these properties, you know, they're looking at credit scores, they're looking at, you know, financial background, can you qualify, all the requirements that a landlord has to file, right? And I don't know that people apply for residents looking out for the greater good of the community and trying to be in a less car-centric environment.
Trustee, how many people, how many apartment complexes do you think there are in Albuquerque that have people with 3 cars or more in them?
Oh, I'm sure there's quite a few that have at least 2, because if you have 2 working adults, we don't have the greatest public transportation in this
Well,
city.
I think that's an
Unless
anecdotal.
we're saying that they don't work.
I think that's an anecdotal argument, so.
All right, well, look, we've got an amendment. I think trustee Benavides.
To follow on that, so we, just for clarification, we were talking about off-street parking on the property, okay? And I keep thinking about the criticism that we got for the Palindrome apartments, that we don't have enough parking. And I heard people come in and say, well, there's 3 bedrooms, there's gonna be, you know, a lot more cars associated with that 3-bedroom, and now there's gonna overflow. People are gonna be parking in the residential areas, which is gonna cause problems for us. Like, that weighs heavy on my mind.
In actuality, the Palindrome project did have enough parking. It just spread the parking, and this is Shanna, correct me if I'm wrong, but this is the concept of shared parking is a very, it's a concept that city planners are trying to use in most downtown areas so that it limits the amount of cars in those areas. And if you look at the Palindrome apartments, you don't see many, you don't see an overflow even now, and it's mostly rented out.
So, yeah, it's 100% rented out.
There you go.
I mean, there is a overflow parking area in 4, 5, and 6, which would then become the shared parking at some future date. And I tend to agree that's likely to work. But these apartments, if they're apartments, they're not necessarily shared with anybody. And so if somebody has more than this lower requirement for parking, it will then overflow into the residential areas, and then people will come and complain about that.
But it hasn't in the Palindrome project.
Because they have the overflow area now. So I probably didn't use the best example, but I brought that up as
I just think we need to.
A concern that people have.
I just think if we want Santa Fe or Taos or that kind of village center, we want to exclude, we want to reduce the car centricity of that place so that it becomes that walkable place that we want. And again, I say, think downtown Santa Fe, think downtown Taos, think Mesilla is not a good example because they have a huge parking lot right next to their plaza. But think Socorro. There's a certain charm to places that have less cars in them that you walk. And if we want to promote that kind of a space, we want to bring in people that have less car centricity and that want that walkable space. And the more concrete we put down for cars, the less walkable it just appears, much less is, you know.
All right, I think we've bantered this enough. I think you made your points. Everyone's made their points. Do we have any other comments, Trustee Brennan? All right, let's go to the vote.
Trustee Benavides?
No.
Trustee Kiefer?
No.
Trustee Rhino?
Yeah, oh,
I'm sorry, Trustee Ranovich.
yes.
Trustee Rhino?
Yes.
No,
The vote is 2-2. Mayor Royale?
no.
Motion fails. 3-2.
Mayor Rael, that concludes the amendment table. I think two things to note is there's an item not included in the table. Trustee Kiefer, you brought up this prohibition on more than 10% of a lot being used as agricultural uses. What I failed to recognize in our previous discussion was that's in the VC zone district, not CC, so that cannot be changed tonight. I'm sorry. And then otherwise, I would just leave the discussion open for Mr. Meyer's request related to non-conforming uses. Now would be the time to discuss such an amendment. If they might offer the planning department's perspective on that. I don't support that change. There is a whole section in the code related to non-conforming uses that tells us as planners how we administer the rules for non-conforming uses. When you put a special rule kind of hidden into a zone district, I think that becomes easy to miss. And so I'm thinking about how to administer the code well and consistently. And I think this would put that in jeopardy. The alternative is that the properties in mention get removed from the zone map amendment, much like this body did at the last hearing for other properties. That, of course, is not a part of this item. That is a part of the next item, but that is another way to get at the request of Mr. Myers.
So Mr. Myers' request, very succinctly, is he would like the, instead of 180 days, he would like a year to consider another use.
Mayor Rael, yes, and if it's the will of the board, I would read the exact text to be added to the CC zone district.
So not to be argumentative with you, my friend, but if you're not paying attention in 6 months, you're probably not gonna pay attention to it as a year. But we had 6 months. So I think, I mean, I'm not arguing either way on either side of this, but I think we might think about that as it relates to the decision.
And Mayor, may I ask, is another option also to close your ears, Trustee Radnovich, because you're not gonna like it, but just to make food drive-throughs conditional again?
Mayor Rael, Trustee Kiefer, yes, that is certainly another option that I think would get to Mr. Myers' concern and his client's concern.
Okay. And one of the reasons I ask is I got several phone calls from individuals, and I'm glad we were able to have this discussion originally prior to this, because the public did pay attention and said, no, like, we get the alcohol, or a lot of the phone calls I get, take out the alcohol, we don't need drive-through alcohol, because those are probably not even legal anymore. But leave the food, because a lot of us, one, had to do it during COVID. And so what options do we have? And we don't have a lot of those options in the village. And so they're like, make it conditional, let us be picky about, one of the topics too was, what if Blake's redoes their structure and they want to drive through? If we exempt out food, then we're telling them you can't do that. And what if we lose them? Because they have to make business decisions.
I would recommend that you go to Blake's and just look at the weight of a lot of the people that use fast food. It's because they drive there and don't walk. So not in all cases, but
I eat a lot of fast food, Trustee.
Say what?
I said I eat a lot of fast
Do
food.
you?
So what are you saying?
So let's go back to the point here. I think, Trustee Kiefer, do you want to move an amendment as you stated?
I would like to move an amendment to make drive-through food establishments conditional. I think that would be the cleanest and the easiest.
Do we have a second?
I'll second it.
All right, any other discussion on the amendment? I think, Trustee Radovich's point is well taken. I think that people driving through these things can become a challenge for sure. But anyway, any other comments?
Yeah.
Trustee Benavides?
So if it is conditional, there has to be the conditions listed out, right? And we don't know what those are for your approval, because, you know, for the example of the guest house, I think you stated that you must approve it based upon these conditions, right? So what are the must approve for these conditions for a drive-through?
Mayor Rael, Trustee Benavides, this is true with all conditional uses, that those conditions are determined on a case-by-case basis for what is appropriate for that site. So future conditions associated with a drive-through conditional use might be, you know, the village will require a certain number of queuing spaces, or if you're gonna have a drive-through, a condition of approval will be that your order board has to face away from the residential area so as to not disturb the residents. There are design choices that can lessen the impact of a drive-through use, and that is what conditions are for.
But we don't know what those conditions are. We're voting to allow it to be conditional, but we don't know what they are, right?
Mayor Rael, Trustee Benavides, yes, they are determined on a case-by-case basis.
Oh, no, I mean, I would think that it would be written down, right?
In other words, there's not a criteria that you would use to decide.
Yeah.
Mayor
I mean,
Rael,
one
Trustee
criteria-
Benavides, true, yeah.
One criteria might be is that if the site was used as a drive-through, that if there was another drive-through coming to the same site, I mean, just for example, as a condition.
Mayor, point of order, if I may. Shanna, but it would still have to follow a site development plan. It would still have to go through a plat. It would still have to go to planning and zoning. The landscape plans would have to be there. Like, the whole thing would have to be there, even though the use is conditional, correct?
Mayor Rael, Trustee Kiefer, it depends. There are thresholds for when a site development plan is required at the village. It's things like brand new development. That, of course, requires a site development plan, so a brand new drive-through would go through that discretionary review. If someone is simply altering an existing building to add a drive-through lane, the next closest criteria is, are you changing more than 20% of your structure? I don't think a drive-through would meet that criteria, so there is a chance that someone could apply for a drive-through on a commercial site that would not go through a site development plan review at P&Z and BOT.
But I'm sure there's other requirements a drive-through would have to meet as far as flow, size of lot, easement size, drive-through, like all that stuff.
Mayor Rael, Trustee Kiefer, I would need to double check the code. I haven't had to approve a drive-through since I've been here. Most codes do have things like queuing requirements and such. I'm not sure in this moment about Los Ranchos' code.
Thank you.
So I guess if we were to vote to approve it for conditional, what we are saying is that we will trust that criteria would be developed. And I don't know what that criteria is, so I don't feel like I have enough information to do that today.
What my concern is with drive up in this area is that we have now basically a 2-lane street. Okay. You know, and if you have, and depending on how they develop the queue, you can have cars in the street, okay, that are gonna be entering the restaurant. That then obviously affects traffic and affects the pattern. So unless there's a way to get cars off the street, maybe into the queue, you know, then that would certainly solve at least the traffic issue. The other part of it, though, is that the constant fumes are going to also affect the neighborhood as well. Okay. You know, and so the option here, I guess it seems to me, is to be able to, and again, and I'm not against fast food, basically, because I've certainly had my share as well. But but again, making it, doing it in a way that is not going to infringe on the neighborhood around it, be doing it in a way that is not going to obstruct the traffic, knowing that we're going to be moving to 2-lane throughout the village. That's a concern.
Trustee Benavides, you might remember that the original plan for the site that Doug Peterson built the strip center on, that is built but not very well rented out, was going to be a drive-through Starbucks, and we nixed that because those neighbors were against it for the pollution reason. Some of them might have even been Chavez's, as I remember.
All right, well,
So, Mayor,
let's go ahead and.
point
go
of
ahead.
order,
Trustee
I guess
Peter.
I would just add, I think that both of you just kind of, Trustee right now and Trustee Radnovich, just kind of prove the point that I think leaving it conditional is no harm, no foul. Because I think if there were a lot wanting to come into the village, we would have seen some. You know, this is just reverting it back to the way it originally was, not making a change. And I guess to what you just said, Trustee Radnovich, the fact that it was conditional allowed the planning and zoning and the board to deny the Starbucks.
I would also say that not making it conditional would attract the right kinds of businesses to Los Ranchos.
But there may be an area in another area that it may work a little better, right? And so by not allowing it, you don't even give yourself that opportunity to have that.
So remember, the point of the original request was just to add another 6 months to the discussion. And we went to, well, we're all trying to solve it here. I mean, I think the practicality is that, if I might just bring it back, do we want to add 6 months to, which is what they're asking, and it seems reasonable to me that 6 months is, I mean, that a year is, I mean, we think about it, and I'll just remind you, I mean, regardless of where we are, we could use all the GRT we can get from all of this corridor. And, you know, I think that we could probably come back and look at these drive-throughs down the road and make a decision whether or not we want them down the road. But anyway, I just want to make that point. So.
Okay, yeah, that might be the best solution.
All right, well, we needed a motion then to add, to make it go from 180 days to 335 days.
I think the request is 365.
Or 365, excuse me.
Full year, yeah.
Full year. So was one of you all make a motion?
Mayor Rael, if I might, could I read in the exact language? Because it's just a little bit more specific than that.
Sure. We're running out of water there, Madam Clerk.
And chocolate.
Okay, so this would be an amendment to the existing non-conforming uses section in the CC zone district to add a sentence to say, all future construction and development on the non-conforming parcel shall be governed in accordance with section 9.2.23 of the Village Code, which governs non-conforming uses and structures. Notwithstanding the foregoing, the 180-day period described in section 9.2.23 D1 of the code shall be extended to 360 days for any properties that become non-conforming upon the adoption of the core commercial zone.
It's 365.
Mayor Rael, Trustee Benavides, the number proposed was 360, but if you would like to bump that to 365, that's the purview of the board.
The request was 365. We're splitting hairs, I think, right?
I think we should make it 299. So what number is it?
Mayor Rael, as proposed by the public commenter, it is 360.
360, okay. let's just leave it at 360. Do we have somebody make a motion to do that?
A motion to increase the time from 180 days to 360. And I want to repeat everything that you said.
As read into the record by the planning director, yes.
That's right. Do we have a second?
Second.
Okay. Any other discussion? See no other discussion, Madam Clerk, call the roll.
Trustee Benavides?
Yes.
Trustee Kiefer?
Yes.
Trustee Ranovich?
Yes.
Trustee Rhino?
Yes.
Motion passes.
Okay, very good. Now we are on final adoption. Well, are there any other amendments to ordinance 306, Madam Director?
Mayor Rael, not unless y'all have something up your sleeves.
I may.
Trustee Kiefer.
I'm gonna go through this quickly. I have a bunch of notes, but I just wanna make sure. So I just wanna make sure that my fellow trustees are comfortable with dwelling units per acre in the CC zone as being 16. It's reduced from VC already, we know, but 16 is rather high, in my opinion. And now's our opportunity to address it if we want.
I would say I'm comfortable with it.
Yeah, I mean,
It's quite a bit less than what we have now.
so C1, we allow, the allowance is different, right?
VC is
We can go-
24.
And then C1 is 16 as a minimum or max? What was that?
Don't recall.
Shanna?
Max.
Mayor Rael, I would need to confirm you're asking about C1?
No, CC. We're
Oh,
talking-
CC, yes, it's
A maximum of 16 is what's proposed, no minimum.
max.
Okay.
No minimum.
Okay. Yeah, Mark, all right, okay.
That's from 24, coming down from 24, is that correct?
Mayor Rael, 24 is what's in the VC zone district today.
Today.
The CC zone was kind of a reduced version of VC, so yes.
Okay.
The other question that I had is we talk about, preliminary site development plan, blah, 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 all the stuff it's got to do. And number 9 says architectural style and color, which I agree with. But should we be more specific, saying New Mexico architectural style and color? Page 101.
Page 101.
Mayor Rael, this is under the requirement for a site plan, which says the site plan shall include, but shall not be limited to, this list of specifics. Trustee Kiefer is referencing number 9, which says your site plan has to reference the architectural style and color of your development. And the request here is, should that be more specific to say New Mexican?
Architectural style and color.
So just to play devil's advocate, is the current apartments New Mexico style? And I say that from the perspective that it's in New Mexico and it's a style. I'm just playing, so
Sure.
I don't know how you define New Mexico style, but.
Well, I know one of the biggest complaints, right,
Sure.
was, hey, it should look more tapered. It should look more Taos Pueblo. It should look more modern farmhouse. It should look, I mean, the public was just all over the place.
Sure.
On, this is not what you'd find in New Mexico. This is what you would find in urban big city. This is what we ended up with. And I'm just bringing it as a topic of conversation of this, if, where these specifics start getting honed in on, or we just let the plans speak for themselves.
Does this apply to new construction?
Mayor Rael, Trustee Benavides, yes. And certain redevelopment.
And remodels?
Well, I would defer to the architect in the room, which I know has a perspective. I think the only thought might be on this particular item. This has been the subject of a lot of conversations in many communities. And I would maybe request, just because of the time and the need for us to really have a conversation, I would like to leave it as is in the ordinance, but have us have a conversation about what this looks like, because I,
a long conversation.
yeah, because I agree that with trustee Kiefer's perspective on this, I want to make it look like it fits in our community. And I agree that the current building may have its challenges as it relates to how it's designed. But I don't know that we're going to spend another 3 hours here deciding whether adobe or brick is the most important piece. And we could be here for a while, unless my trusted architect has a perspective that clarifies this. Well, in terms of just, is there some term in the world of architecture that we could put in here that would satisfy what we're trying to get at?
Architecture changes over time. And so there are modern interpretations of older styles that work. So it could be that we leave it more open as opposed to kind of specifying it, because architects are always coming up with ideas that work on the materials maybe a little bit differently than others have in the past. So specifying it to a really tight style, like say downtown Santa Fe does, where it's Pueblo Revival, I believe that is it in Santa Fe, may not be where we want to go. You could interpret that building that I referred to earlier, that's an office just south of the Plants of the Southwest, is a modern interpretation of New Mexico style because it uses the rusted steel like the roofs of northern New Mexico style get over time. So it's not a specific style, but it does work with the materials from a specific style, but in a different way.
And I know it's a loaded question, right? But it's things to think about and put on the record that we need.
No, there's no question.
The other big one that I think is the setback is still at 5 feet from the road. That was another big one that we heard with the existing property. Do we want buildings that close to the road still?
What does that have in the code right now? Is it
Mayor Rael, it's proposed as a minimum of 5 feet and a maximum of 18 feet.
I don't want to get into a lot of, what I'd like to do is, this is a philosophical discussion, I think, about what a village center should be in a lot of ways. If you look at, for instance, any of those places I've already mentioned, and even say Nob Hill. Maybe Nob Hill's not a great example, but say the Huning Highland part of Albuquerque. You see buildings right up next to the street because that's where the door is. And that's where people used to go before they relied so much on cars. And so now there's more high density with the lofts at Albuquerque High and all the other buildings that have been proposed and built over there that are trying to bring back that kind of community feel that a tighter street kind of begats. And the other thing it tries to do is it tries to slow down traffic. There's proof in scientific studies that have been done that the closer you bring landscaping, the closer you bring facades of buildings to streets, it slows the traffic down because people walk there, and that also helps slow the traffic down. So there's a lot of ways to look at that, I think, trustee, that probably need to be vetted with the community in a more robust way, maybe, than we have up until now.
Any other comments? Trustee Benavides?
Oh, sorry, you can go next.
Yeah, what I was going to suggest is that we, again, we kind of leave it as is. However, with the caveat that we put this on a future agenda, and that we we have a way to get input from the community about it, so that we can, again, have some language that is, that's, conducive to new development coming in, as well as satisfy the needs of the community. And so I don't know whether we can sit here and actually come up with new language or not, because we all have lives, okay?
May I suggest something, sort of cut this off? You could use and say that at this point, to fill the gap, the architectural styles could be as approved in the C1 zone. That has examples, should be incorporated architectural styles, Northern New Mexico, Spanish colonial, Pueblo revival, territorial, mission Mediterranean, and ranch and combinations thereof. So that would give you some criteria rather than an open end stick by simply saying at this point, the styles are permitted in the C1 zone.
All right, so we're talking two different things. We're going back to the previous question, which was what she was asking.
Mexico style, yeah.
And now we were on setbacks. So let's go back to that. I think that explanation is at least much more
The
palatable
definition works.
to the rest of us.
Yeah, yeah.
I agree.
All right, so let's have an amendment then to what he said.
So an amendment to the architectural style as listed on page 101 to match the C1 architectural requirements.
Yeah, or it could be saying is provided in the C1 zones under section 9.2.21B1.
That is the amendment.
Okay.
Do we have a second?
Sure, I'll second that.
Okay. Any other conversation? All right, all those in favor, let's have our friend call the clerk, call the roll.
Thank you, Mayor. Trustee Benavides?
Yes.
Trustee Kiefer?
Yes.
Trustee Ranovich?
Yes.
Trustee Rhino?
Yes.
Motion passes 4-0.
Okay, so now we got the architectural piece resolved. I think the issue,
Setback.
now we're back to the setback.
Okay. So I have no problem with entertaining further public comment. That's always a wise thing to do. But getting back to how that came about and what the complaints are with the minimum setback, for the apartments, it was really a combination problem. It was a combination of 5 feet setback and the 3 stories, right? That was, I think, the real issue. And so I understand the motivation for lower setbacks for 5 feet and that sort of thing. It's because it's more pedestrian friendly as people walk along the sidewalks. If there's windows there, they can look in and they're more likely to walk into to the business. So that would be something that should be explained to the public if you have public meetings, right?
Sure, and on that point, we went from 3 to 2. So you already have compromised that a bit in the sense of the height.
Oh, yeah. So that's right, yeah.
So you have that height.
Yeah.
So. All right, anything else, Trustee Kiefer?
Nothing else for me?
All right, very good. So we are now on final adoption of ordinance 306. Any other amendments? Seeing none, Madam Clerk, call the roll.
Thank you, Mayor. Trustee Benavides?
Yes.
Trustee Kiefer?
Yes.
Trustee Ranovich?
Yes.
Trustee Rhino?
Yes.
Ordinance number 306 with all amendments passes.
I would have voted yes, just for the record. We're going to take a 2-minute break because we've all been sitting drinking a lot of water, so if you can just give us a 2-minute reprieve here.
Guess you were right. I should have brought my sleeping bag, huh?
I'm going to buy everybody a book. I'm going to buy you, Gil, the mayor, and Jennifer a book.
Oh, you are?
Yeah, this is the book. And it's a great book by a planner.
Oh, wow. Okay.
Did you read the rest of the title?
Yeah. It's great.
I'm going to buy you each this.
Oh, you are?
And
Okay.
it's going to be my Christmas present.
Oh, okay.
With the disclaimer that if you open it,
Will do. Hey, sir. I know.
Not to mention the public meetings.
Right, yeah.
Right,
Yeah,
right.
yeah. Yeah, exactly.
That's exactly. Thanks, thanks, Robert. Are you leaving now? You can't leave. You can't leave, you gotta stay.
How are you?
Hanging in there.
I was thinking about you yesterday. I drove up to Mora
Oh, uh-huh.
for a friend's family's funeral anniversary.
Yeah.
I was driving, I was thinking about you guys driving through
Canterbury.
Canterbury.
I love that place. I wish they weren't closed seasonally, especially now that we've had such great weather. We could have taken the RV up there, I don't know how many times by now.
And you know, it really is sad that there's no snow. There's nothing up there. It's just, you know, in the shaded areas, you see a little bit of remnants from the last storm.
Yeah.
But heck, I drove into Mora and it was last night. I walked out just like the rest of the day in here. And I took a jacket thinking it's going to be really freezing up there. It wasn't, I mean, it may get cold like that. But not
Sure.
that.
Yeah. Oh, it's so dry.
It is so dry.
Sad part is, have you been to Panerai since the fires then? Have you been into
Yes.
that?
Oh, I know. It's just.
I'm okay.
I think I'm almost done with this. No, wait. All right, let's get trustees over here. Good, the one that went to the restroom.
We lost George again.
Okay,
Oh.
Darnell, you ready to rock and roll here in a second? Okay.
Well, you have to decide for yourself. It's at least very good, but is it the best? It's up to you. Their sparkling is excellent.
Oh, okay. We'll be back in session here. The time is approximately 10 o'clock. May I remind you, the time is approximately 10 o'clock.
Yeah.
We are now on ordinance number 307, approval to adopt an ordinance ZMA-2501, request by the Village of Los Ranchos de Albuquerque to update the official zoning map of the Village of Los Ranchos by amending the existing VC Village Center zoning designation of certain parcels to the CC Core Commercial. Ms. Schultz to explain.
Mayor Rael, trustee members, this ordinance is a follow-up action to the action you just took on the previous ordinance. You created a new zoning district as a part of the last bill. This amends the zoning map to operationalize that new zoning district and actually apply it to parcels within the village. I'm going to share a map on the screen. At the previous hearing, there was some discussion on the zone map. Everything that you see within the yellow boundary is subject to change via this ordinance. This map has been updated since your previous hearing to reflect the requested removal of the properties. I'm not sure if you can see my mouse moving here, kind of in the southwestern part of the boundary. Those properties were scheduled to be converted from VC to CC at the request of the property owners and a motion made by this board. Those have been removed from the conversion to CC. The outcome of that is that they will remain as VC. I understand the property owner's ultimate desire is to have those properties zoned C1. We cannot do that as a part of this process. I think they understand that. So what you see before you tonight would change everything in purple to the new CC zone district you just adopted. Everything in this neon yellow greenish color would remain VC and would be the new VC zone district, which is kind of a combination of the existing VC and VC project area. Staff has heard from a property owner or a representative of a property owner today, Mr. Myers, who has requested that additional properties be removed from the conversion to CC. It's at the will of this commission if they would like to do that. There are 3 properties that this owner is requesting. I'm going to zoom into my map and show you specifically. So these are the ones that we took out for consideration of the Chavez's. The 3 that are requested by Mr. Myers are this one that's labeled 41G, this one that's labeled A1, A2, and this third one that's generally described as A1, A1. With that, I'll stand for any questions related to the zone map amendments.
All right. Before that, do we have anybody signed up to speak?
Yes, Mayor. The first individual is Mr. Matt Myers. If you would approach the podium, state your name, and you have 2 minutes.
Matt Myers, again at 1401 Central Avenue, Albuquerque, New Mexico, 87104. Thank you, Mayor and Board of Trustees. This is a long night, and you guys are very well informed. I am still going to request that these properties are removed, even though we you did vote to extend the period under the non-conforming. And the request is based on the fact I think it's reasonable to remain a village center because of its location. And further, once you become non-conforming, you have a lot of additional rules and regulations that govern future development, which my client would prefer not to have, but the use would still remain conditional. Drive-throughs would be conditional, and when you request a conditional use, of course, you have to come in and there has to be a decision made and conditions can be put in place. So my request is to remove the 3 properties and have them remain in the village center zone. And that's all. Thank you.
Okay, thank you.
Thank you, Mr. Myers. The other individuals we have is Mr. Ron Chavez. If you would please state your name and address for the record, and you have 2 minutes.
You want us to put them back in? Is that what you want?
Ron Chavez, 428 Chavez. About the only thing I got to say about this one is Matt's entitled to what we're entitled to. That's pretty much it.
Okay.
Okay, thank you.
Thank you. Mr. Stephen Chavez. Stephen Chavez, it looks like he's left, so that concludes public comment on this item of business.
Thank you. Now we've got motion to approve ordinance 307. Do we have a motion?
I'll make a motion.
It's been moved. Do we have a second?
Oh, yeah, has he made the motion?
I'll make a motion to approve 307.
I wanted to help you out there. Move a motion.
I didn't have my microphone on.
Do we have a second?
Second.
All right, it's been moved in second. All right, any discussion?
Sorry,
Go ahead.
I do.
Trustee Kiefer.
I just have a question, and this kind of goes back to the order. Not that I'm opposed to what Mr. Myers is requesting for his client, but could we have essentially removed these properties from this zoning back to VC without changing the non-conforming use on the previous?
Mayor Royale, Trustee Kiefer, yes, I think ultimately if these properties are to be removed from the zone map amendment, that reaches the same goal. Actually, it's probably better for his client if they're removed. You would not have had to do both, to answer your question.
Okay.
And I guess my question is, what gives his client the most flexibility?
Mayor Royale, Trustee Kiefer, removing them from the zone map amendment would keep the drive-through as a conditional use. As Mr. Myers testified, if they move forward with being converted to CC, they do get the non-conforming language, but they become non-conforming as
After
opposed to
360
remaining a conditional use if they stay in the VC zone district.
Okay.
And I guess my comment would have been, and we probably couldn't have done it from public notice standpoint, but to combine the two, because what I'm wondering is, did we give a benefit of the non-conforming to other properties by approving it in the previous ordinance that we didn't necessarily have to and could have just solidified it in this method?
Mayor Royale, Trustee Kiefer, the language is written very specifically that 360-day language was applicable only to non-conforming uses that were made non-conforming as a part of the creation of the CC zone district. My analysis is that is the only property that applied to. And so I don't think that you created a benefit for other property owners based on what I understand the changes to be.
Okay, thank you.
Just for clarification, Shannon, so moving these properties out, then the 360 would not apply.
Mayor Royale, correct. It essentially becomes moot.
As it relates to the request. All right, well, look, it's, go ahead, Trustee.
I guess my concern is that we then keep on chipping away.
Yeah.
You know, at it, and you know, and I understand the rationale for it. Okay. But at what point then do we have to, or should we, be concerned about making sure we are consistent and uniform in the way that we go ahead and make these kinds of decisions? And so it just strikes me as a way to start kind of unravel the onion a bit, you know, and bring up other property owners who may have a very similar kind of issue. So I don't know where it's going to, where it's going to go. You know, I would, you know, I guess leaving it in the zone, in the current zone, and having the owner come back to us with a non-conforming use, I mean, maybe a way to address it.
Which is what we already did.
Yeah.
Okay, well, are there any other amendments that we have, that we want to make on this particular? I would say this, and I think I can, I'm nervous about continuing to whittle at this. Inevitably, we're going to end up with, with a piece of
Patchwork.
well, yeah, without a lot of work. I would say, Mr. Myers, if you can just, maybe from my perspective, is that we helped get some, we helped them out on the time frame. I would not be interested in moving any else out, but at this point. But I don't know, trustees, if you all have the same sentiment. And if not, then we probably just need to, unless there's any other amendments.
Mayor, I guess it's a hard pill for me to swallow just because it is still surrounding the other properties that we allowed to move out. And we did do that at the previous special meeting, where this is the advertised meeting. You know, I think if it was a piece that was far north, I may say, look, it's not in that contiguous area. And I guess I'm looking for someone to convince me, or maybe not. Maybe you've got the votes. Maybe just put it up to a vote and let's see.
So you're saying that, given that we already allowed one change back to VC, that we're being inconsistent if we don't do it again?
And we did it before even the advertisement, right?
So I would say that the goal is actually to go back to C1 and not to stay at VC, and which would be contiguous with those other C1 properties. So it's a different situation, right?
Yep.
Good point.
All right, well, look, Trustee Kiefer, if you'd like to make an amendment, if not, and we can have that conversation, or if we just move on to final passage.
We can proceed.
Okay. All right, any other questions? If not, it's been moved in second. Madam Clerk, to call the roll.
Can you repeat the motion?
The motion is to approve.
Yes, the motion is to adopt ordinance number 307.
Oh, okay.
As is. Trustee Ranovich moved, trustee Reinao second.
Okay, good.
Trustee Benavides?
Yes.
Trustee Kiefer?
Yes.
Trustee Ranovich?
Yes.
Trustee Reinao?
Yes.
Motion passes 4-0 adoption.
Okay, we now move to ordinance number 308. Approval to adopt an ordinance TA 25-03 requested by the Village of Los Ranchos de Albuquerque to amend the text of 9.2.2 Planning and Zoning Commission, 9.2.4 General Regulations, 9.2.7 A1 Agricultural/Residential Zone, 9.2.25 Application and Approval Process, and 9.2.27 Conservation Development Standards Permit. Madam Director, to explain, please.
Mayor, Rael, trustees, this is a change to two portions of the zoning code, one related to the conditional use process. Today, the code allows for an administratively approved conditional use unless there are adverse comments, in which case the request gets kicked up to a planning and zoning commission decision. So the first change in the conditional use section is to strike the administrative approval in its entirety, which would require all conditional uses to go to planning and zoning. There's another minor change in that section that adds some text related to the justification that says the applicant has to provide the justification. That's unclear in the code today, and staff has been asked before to justify an application for someone, and that's not our role. We check that justification, so adding that text. Second, related to variances, is a proposal to delete variance criteria number 5. There are today there are 5 ways in which an applicant can try to prove unnecessary hardship. The 5th one states other relevant factors exist that when taken into account indicate that granting the variance is substantially justifiable, giving proper weight to the interests of the property owner, the public interest in protecting and fostering the character of the vicinity and the village, and the intent and purpose of the master plan and zone code. As previously described, this is kind of as I describe it, a get out of jail free variance criteria where there is not anything objective to consider. Variances are really intended to be used for when your lot is so abnormal for reasons outside of your control that you cannot meet the standards of the code. Criteria number 5 is not within the spirit of that intent, so that is proposing to be stricken in its entirety. That's a summary of the 2 changes. I'll note that there's one proposed amendment for Trustee Kiefer related to a change. This is going to be on page 195 of your packet. The Planning and Zoning Commission, within the conditional use section, proposed to change the wording from injurious to create material adverse impacts as a part of the criteria. And Trustee Kiefer expressed an interest in kind of undoing that change and keeping the phrase creates material adverse impacts instead of be injurious. With that, I'll stand for questions.
Okay, Trustee Kiefer, would you want to move that amendment?
I'll move Amendment A of ordinance number 308.
Do we have a second?
Second.
All right, any perspective on this? Injurious?
I don't see why I care what the wording is.
Okay. Trustee Reddick?
I don't really either.
Okay, all right. All right, well then, Madam Clerk, to call the roll.
Thank you. Trustee Benavides?
Yes.
Trustee Kiefer?
Yes.
Trustee Ranovich?
Yes.
Trustee Rhino?
Yes.
Motion passes 4-0.
Okay.
And Mayor, just for the record, there were no individuals who signed up for this item.
I apologize for that, you're right. Okay. Any other changes to this ordinance? If not, I'm sorry. Go ahead,
Can I ask a question of
Sure.
Director Shanna? Do you have a recommendation for all these changes?
Mayor Rael and Trustee Benavides, my recommendation at the Planning and Zoning Commission level was that these changes should be approved.
Okay. I mean, I guess I would state that maybe people should watch what they ask for because they might get it, right? So now conditional approval will not be permitted solely by the P&Z director.
Mayor Rael.
How much of a workload are we transferring to the P&Z?
Mayor Rael, Trustee Benavides, there will certainly be more cases that go before the P&Z for a conditional use approval. I'm not so worried about the burden to the P&Z. I think what is worth highlighting is the burden to the applicant. The administrative approval can happen in pretty much 15 days flat if there are no adverse comments and there's no major cost associated with that. Once you get up to a public hearing level, it's about a 6-week timeline to get before the P&Z by the time we have to do the notice and the staff report, et cetera. And there's also an additional cost because the applicant has to pay for the public notice associated with a public hearing, which can range anywhere between, the last couple that I looked at in the file were anywhere between $70 and $120.
But you're still recommending approval?
Mayor Rael, Trustee Benavides, yes.
Okay. Any other concerns? If not, Madam Clerk, to call the roll.
Mayor, I don't have a motion to adopt
apologize.
ordinance 308 yet.
No, I'm sorry. Do we have a motion to approve ordinance 308?
Motion to approve ordinance 308.
Do we have a second?
Second.
All right, hearing no other questions, Madam Clerk, to call the roll.
Trustee Benavides?
Yes.
Trustee Kiefer?
Yes.
Trustee Ranovich?
Yes.
Trustee Reinao?
Yes.
Motion passes 4-0, adoption of ordinance number 308.
Well, thank you very much. We are now at the CFO, Ms. Silva, and her financial report.
Thank you, Mayor. Trustees, before you is the cash report for November 30th, 2025. We had an ending cash balance of $14,621,834.05. This was an increase of $246,831.29 for the month. And we still have a year-to-date excess of revenue over expenditures of $314,384.22. There were no unusual items this month, but there were 6 significant expenditures that are listed here before you, and I'll stand for any questions.
No questions? We'll move on to, thank you, Ms. Silva, and now we'll go down to Mr. Avila, your report.
Oh, that's,
Oh, I am so sorry. Would you like to go?
I do have a question.
Okay, I'm sorry, Ms. Silva. Question from Trustee Ranovich.
It's for Bill. When are we going to get done with the palindrome case?
Oh, it's on the checking?
Say what? Yeah.
There's a check cut
Yes.
for it.
And Trustee Radnovich, the palindrome case has been outside of the legal parameters for months and months and months. It's all in the planning and zoning and board of trustees to approve or not approve their plans. So it's been outside of the legal department for a long time.
But you're still charging us for it.
That's because I'm asked to give an opinion or provide documents or something for everything that comes along for approvals. Yeah.
Mr. Chappell, may I clarify? Trustee Ranovich, do you mind? When you, so are you being asked for still palindrome stuff or other planning and zoning issues? And I mean, I guess what's the breadth of what you're being asked to do?
Mayor Rael and Trustee Kiefer, the things that we are asked to address is very, very broad. One of the few that we keep separate time records on so that you know exactly what is there is because palindrome, because it was a major one. And so that one is accounted for differently. And so you see an itemized on the palindrome, which, you know, not everything is itemized. So across the board, we're getting asked a lot more than palindrome. That's not the major piece. But with every application that they make and everything they do or they don't do, or they don't clean it up, then we're asked for interpretations of the documents as what is required and that sort of thing. There is no continuing litigation we're involved in at this point. It's all approvals for site plans, preliminary and final plats that they're going through.
If I might ask a question, Trustee, Bill, why don't you just give us a lump sum and get it done? ask us for a lump sum instead of drawing it.
It was simply because that was a major item that needed to be resolved when I came on board. And I thought it was better that the village knew what they were spending on that particular case because we not only had my office, but we had the Ward Law Firm. And from a disclosures perspective, I thought it was important this board know what was going on in that particular case more so than some of the others.
So other entities, I'll say, are getting bills too?
Not by me.
No, not by you.
We have other lawyers that are doing things like a couple of the cases where we have, the Ross case and some of those, there's another law firm. And those we account for separately. We typically account for litigation separately than we do for general work.
All right. We'll go now to Mr. Avila.
Mr. Mayor, Board of Trustees, we have our staff reports here, and you've had a chance to read them. I'd like to point out a couple of things. On January 7th at 6 o'clock, we'll be having the legislative town hall here, and early in the day at 3:30. We'd like to recognize a lot of the efforts of our staff and the legislators and other elected officials that have assisted in getting the Old Village Hall to completion, and we'll be having a groundbreaking and recognizing and a bit of a ceremony there. Our legislative requests have been filed, and those are the ones that were on the ICIP previously meetings that we've had. And beyond that, we're pursuing Water Trust Board funding. We've had that, and then also funding for transportation projects. You've seen recently the utilities being moved, P&M gas on 4th Street. And then you've also seen today some of the striping that we've been planning to do so that the lanes are now changed. So you have one lane in each direction. So that's there, and give people an idea of how that's going to look when it's all said and done. One of the projects being completed because we are using the funds in the Del Norte Open Spaces irrigation project in 2026, and that'll have to be done soon before the actual MRGCD water is available, so that we can get those out to the fields. As far as public safety, Fred has had, he couldn't be here, had to be away. But one of the things he's done is a lot of traffic study to get warrants, in essence, the data that says speed humps are good in this location or otherwise, and a lot of those have been put down this year. So you've had a lot of progress there. There's a standing resolution on how we're supposed to do speed humps. So one of the things to do is look at the speed and the traffic, and that was done by Fred and got that to us, and our folks got that done with the funding we had. And then some of his data that he's shown, one of the pieces that you look at is traffic stops. I'm gonna tell you from a police public safety perspective, one of the best crime fighting activities you could have is a traffic stop, because you're able to pick up on other issues that might be having with that particular vehicle. So the fact that that's leading numbers is good from the perspective of BCSO. And so with that, I stand for questions.
Any questions of Mr. Avila? I think the two points I'd like to sort of expand on. Number one is, again, as we all confirmed, the staff today for the Agri-Nature Center and our interest in continuing to invest in that facility. As we move forward with here very shortly, once we hopefully get this approved by MFA, having the funds to start the study for the entire park, which I think is a really important piece of work that needs to happen. We're also doing some work on the Del Norte open space and the buildings that are there and reconfiguring, and we'll be making a presentation to you all here probably in the first quarter of next year. We also are going to have a community meeting the first quarter of next year on the Chavez Trail project. And my perspective on that is just simply to present what the DOT has, if you will, has changed their criteria a bit in order to help us see if we can make that project work. But my goal here is to have a community meeting with anyone interested to come in and look at what might be possible, with an eye to deciding, to making a decision. Do we move forward with it, or do we decide to do something different? And so we'll be setting it up and having some community meetings and on that aspect as well. I think the only other point I would make to all of you is that this weekend's event with the light up Los Ranchos and the tree lighting, et cetera, appreciated you all being there. Yet is another project that our Main Street folks need to have in order to eventually qualify for state funding. They have to have 3 projects, and now we've gotten 2 under our belts. There is another one that we're putting together with them to help us be the go-between, Trustee Kiefer in particular, since you're involved with them. Having Magda and be the coordinator of the community, of the business, if you will, information as we do 4th Street, Phase 2, coordinating with the businesses and giving them information. That'll qualify for yet a 3rd project that will then put us in a position to get qualified as a Main Street program for the community. So those are a couple of other things in the department presentations. But with that said, now we'll move to item 11, reports from the Board of Trustees, and we'll go to you, Trustee Benavides.
Okay, I had a lot to say, but given the late hour, I will try to make it quick. But, you know, this is our last trustee report, right, for George and I. So what I wanted to talk about was about preserving our agricultural roots and the evolution of the 1958 Village of Los Ranchos to what we see today. And that could turn into a long discussion, and maybe for the minutes, I can give you the longer version, Danielle, if you're willing. I can just write it down and send it to you. But in 1984, a lot of these, the old timers that were here in the village for the incorporation of the village were still alive and were my neighbors, actually. Hartnett lived across the street from me, okay? And what I heard from these people is the main impetus for forming an incorporated village of Los Ranchos was to stop the proliferation of trailer parks. That was the number one thing on their mind. And of course, you know, 4th Street was not originally part of the village, and you know, later on, it wasn't deemed to be important at the time, right? Now, in 1958, of course, this was a rural village, right? You know, we didn't have a lot of the city services. People were still burning their trash. And it did look very rural, including 4th Street, you know, and people have a very nostalgic view of what it looked like, and it's not going back to that. So agricultural property was was inexpensive and affordable by people that didn't have much money. And so that's why you would see farmers that are actually still around today, you know, people like the Chavezes on Chavez, people like the Martinezes that live on El Pueblo, and the Jaramillos that live along Guadalupe Trail. They came here to do actual farming as a means of supporting their family, right? That is gone, right? So what do you have left? You have gentleman farmers like myself, right? Gentlemen, gentlewomen farmers like myself. People that do it because it's in their nature, right? They love being outside and getting their hands dirty, but don't need to rely on any income for that purpose, right? And of course, you have people that have big, huge estates that actually just like having vineyards or seeing it farmed, but don't really want to work on it, right? So that's the mix you have today, right? And so, what I wanted to address is some comments that you made at trustee reports for the last BOT meeting about carrots and sticks, about how do we preserve our agricultural land. And there was a discussion about, well, if you have property that where you get an agricultural exemption on your property taxes, then you should be penalized if you were to then move it to a residential use. That's a stick approach. I think that's a bad approach because unless you're very wealthy, if you buy a piece of property, which we were fortunate enough to do back in the 90s before things were terribly expensive, you rely on the fact that it had rights, and with those rights, there was a particular valuation associated with that property. So if you remove the right to be able to and that, this would be an extreme case, but I think I've heard people talk about this. Remove the right to do a residential house if it was put into an agricultural exemption. That lessens the premium of what you can command for if you were to sell that property. So the reason I'm willing to leave my vacant property, our vacant property, as keep it in agricultural use, is because I'm not losing that value, right? If I ever felt that that was under threat or I'll be penalized in some extent, I would do a different calculation in my head, and I said, no, I can't lose that. I'm not a wealthy person. I need to quickly build a house and sell it to get my money out. But as long as I have that right, that value stays with that property. So I just want to warn you about penalizing people if they were to try to move their property out of the agricultural exemption. So I think that's the gist of what I wanted to say. I'll leave it up to you if you want me to give you a written version of that, or if you want to capture word for word everything that I said.
I'll try my best, trustee.
And I will no longer complain about you not adequately covering what I said.
All right. Trustee Ranovich.
I wrote something and I was going to veer from it, but I think I'll just read it more or less.
Okay.
When I first ran for trustee, I had a pretty simple goal, just to give back to the community that had given so much to me. Because before this, most of my work was done as a consultant, like the 4th Street project. And we'd been working at the Village, our company, and actually before the company I'm in now, for decades. It was only recently that we've had the other landscape architects and planners kind of work here. And when I came into the public service, I learned pretty quickly that it had much more challenges than I thought, because Gil and I got attacked for things we didn't even do. So, a project that I'd been involved in before my election even became the source of a significant public discussion. And that experience shaped the rest of my board time. And I would venture to say that it probably did for Trustee Benavides too. And while it wasn't always easy, it was an important reminder to have passionate people in the Village and trying to respect the future of the Village. So I can respect that of everyone that spoke. As the new board members take their seats, and my time comes to a close in another 2 weeks, I'm going to do everything I can to use that time. No, I'm just kidding. Aren't we having a special meeting at some point? I'm just asking. Public service is rarely simple, and differing perspectives are part of the process. And, I realize that probably more now than I ever did. I respect the many voices that care deeply about the Village. I really do, even when they may not agree with me. So I'm pretty grateful for the opportunity that I had in service, and confident that I acted in what I thought was the best interest of the Village. So I look forward to continuing involvement in Los Ranchos in other ways, and I wish the incoming board the very best. So thanks for the opportunity to serve, everyone.
Mm-hmm. Thank you.
I'm glad there were so many people in the audience to hear that. Thanks, Vincent. Thanks, Linda.
All right.
Spread the word.
Trustee Kiefer.
I don't have much. I guess first let's start with the business before I get to the sentimental part. I'm glad we're finally getting positions filled at the Agri-Nature Center. I'm glad we're getting positions filled throughout the Village. I think, when I first came in, I was very concerned about how lean the teams were running. and I think they still are. So I hope we're not losing any more, and we don't have a turnstile, effect here in the village, because that's really concerning to me. So glad we're getting those positions filled. Gil, George, I know we didn't always agree. I know we started off on rough paths at different points, but it's been a pleasure. I appreciate working with you all. Sometimes it's a healthy dialogue. Sometimes it was a combative dialogue, but I think we worked past it. And I wish you the best, and I hope to really keep in touch, because I do think your viewpoints matter, and I'd love to hear, if you look at different things in the village, or as material comes out and you have an opinion, please reach out, because I'd love to just have the outside perspective as well. So thank you for your service. Thank you for what you did for the community, and yeah, best of luck to you guys, and I hope you get to do something fun on Tuesday nights.
That's for sure. Trustee Mann.
I think we will.
So we've been through, we've been through some difficult times together, but Gil and George, I mean, I've certainly have gained certainly a lot of knowledge in the questions and the discussion that we've had from both of you. And that's been very rewarding for me, because I just didn't have that background. But, I think that we worked through a lot of the earlier stuff that was going on in a way where we could work together. And again, we might not have always agreed, but always had the best intent of the village. And the contributions that Gil, you've made in terms of understanding water, has been very, very helpful, to all of us. And hopefully you can continue kind of along that line, helping us along the way, because we haven't solved it yet. All right. And George, in terms of your architectural background and your feeling for community and your feeling for the central business district, I mean, I agree. I agree. I mean, I'd like to be able to get us to a point where we really establish a CBD that's really meaningful for the village. Okay. And that's distinct from what is going on all around us. So again, the contribution has been extremely helpful. Gil and George, I mean, if you have issues that you want to bring to the board, I mean, please talk to me. Sure. And I will certainly reach out. I hope that we continue to, to get together from time to time and just kind of check in with each other. But it's been very rewarding, and it's been a good experience, I think, working with both of you. So again, congratulations on your successes here, and wish you the best as you move on to other challenges. So thank you all.
Mm-hmm. Thank you for your kind words to both Trustee Kiefer and to you, Frank.
I thank you both.
Sure. So with that being said, we have a presentation for both Trustee Benavides and Trustee Ratnovich, thanking you for your service to our community. And as Danielle gets that put together, let me just say the following. Public safety is a calling, and it's one of those rare opportunities that not everyone gets to sit and serve in these positions. And please accept these plates that commemorates your work here at the village.
That's very nice.
On
Thank
behalf
you.
of all of us
Thank
in
you.
the community. Thank you.
I thought it was
for your
going to be a
service.
20-pound turkey.
No turkey.
Oh, that's great.
But as I was saying is, not a lot of people get the opportunity that we have been given to serve the community. And so you all have done that with distinction, and appreciate you all very much. The good news is both of you now can have lunch together with me, and we don't have to worry about a quorum. And that's good too. And then the last thing I would say, look, as I say, old or retired elected officials never go far away. I've got lots of ideas for both of you to help us with some projects in the village, sitting on committees, helping us with ideas. And I would say to both of you, look, I wasn't here for a lot of the maybe early conversations that happened and the challenges that we had, but the one thing I will say, and I would say to all of you, look, it's been a very interesting year for all of us. I've been honored to be able to sit up here and work with you all, and I thank you all for the support that you've given the staff and you've given us, and me in particular, in moving this community forward. And George, you and Gil, really are if you will, have been here through the thick of it. And so we thank you for your service. Thank you for doing what you did for our community. And as we go out and celebrate the holidays, just remember that we're all very grateful for your service. And Trustee Kiefer and Trustee Renau as well, enjoy your holidays. Everyone else, enjoy your holidays. It's our last meeting of the year, and we shall all sit tight to see what the new year has to offer for all of us. But with that, I think the only thing else I would say is, just for you all's information, as we've talked about before, Fred is going to be retiring, and so we're busy looking for an individual to fill his shoes. And so we'll have someone soon, and so our goal here is to continue to make strides to make our community better and work together to make some things and realize some things for everyone. So with that being said, we need a motion to. Do we have any other presentations, Madam Clerk?
No, Mayor, that should conclude the presentations for this evening.
All right, very good. We need a motion to adjourn.
Motion to adjourn.
I'll second it.
A second. All those in favor signify by saying aye.
Aye.
Aye. All opposed, same sign. Meeting is adjourned. The time is approximately 10:48.
I didn't need my sleeping bag.
Came close, yeah.
This is really nice.
Trustees, if you
It is really nice.
we can take a picture of you two
Yeah.
with your plates.
Oh, with our plates.
Yes, in front of the dais would be lovely.
Yes.
Okay.
Merry Christmas, Bill.
Merry Christmas to you and your husband and your extended family.
You and your family as well.
Where are we gathering? In front of the tree, you said, or? Oh, here, okay, okay.
Thanks for the good words, you guys.
Well, thank you. Merry Christmas, sir.
Merry Christmas.
How's your wife doing?
Oh, did you? Nice.
Yeah.
Oh, in my chair?